Okay. I'd like to call the meeting of the Inspector General Ordinance Drafting Committee to order. We'll call the roll here. Mr. Bornstein. Here. Ms. Ashton. Here. Mr. Baker.
Here.
Ms. Rainey. Ms. Ehrenberg.
Here.
And Ms. Deckler.
Here.
And Kurt Bressner is here also. Second item on the agenda is the approval of the minutes of February 9th, 2011. You received those subsequent to the agenda packet going out. Everybody have a chance to review the minutes?
I'll move their approval.
All right, actually, just a couple of corrections. Okay, go ahead.
Thank you, Mr. Bornstein. Thank you, Mr. Chairman. Yes, I'd like to correct something in the minutes. On page 8, it recorded the votes of everyone. It said if the substitute motion failed 3 to 4. It's actually 3 to 5. I voted no as well.
2 to 5.
I'm sorry, 2 to 5. Yes, excuse me. So, how'd they get 3? I guess they had me voting in the wrong way.
All right, which paragraph is that? Page 8, did you say?
Page 8, the penultimate paragraph.
Okay, I see. Okay.
I voted no, so it should have been 2 to 5.
Okay. Any other corrections?
Just on page 14, maybe he goes by Robert, but I thought his name was Scott Maxwell.
It is Scott.
Okay, yeah, okay.
You're correct.
I've always known him as Scott. Just a correction.
Okay.
So the correction, Mr. Chairman, the correction on page 8 would be to change the vote to 2-5 and add Mr. Ehrenberg's name among those who opposed.
That's correct. And then the other change would be to correct on page 14. Mr. Robert Maxwell should be designated as Scott Maxwell. All right. All those in favor of approving the minutes as corrected?
Aye.
Aye.
Okay. Second item is public comment. Third item, rather. Oh, I have to call the cards. I thought this was automatic, but it's not. Mr. McAllister, Bruce McAllister. Yes, that'd be great. Thank you.
I'm here to represent the mayor of the town of Palm Beach to present a resolution unanimously adopted by the council of the town of Palm Beach, urging at every governmental level that the jurisdiction of the Inspector General of the county be extended to the school board and to the sheriff's office, and in particular to represent the mayor to urge you to resist any weakening of the role of the Inspector General, and especially in drafting its enabling legislation. And I'll hand this up.
All right.
to
Thank you very much. You can keep this copy of that. All right. Thank you. Suzanne Squire.
Thank you, Suzanne Squire, 805 North Lakeside. I'm really disappointed in this whole process. I was invited to, kind of get in on this at the beginning when we were nicknamed Corruption County, and I brought up a lot of similar points over and over again. And there are words that are being written out in here. There are people that are involved that are not independent, that shouldn't be on here. Waivers are still going through. And the thing I'm the most bothered by, if I understood this whole process correctly, because it's getting crazy, some people want it written a certain way, and no matter what the votes are, we're getting that version. And that's just really, really wrong. We have unelected officials that are making these decisions. People think it's for their protection. I'm from Lake Worth. Apparently, our funds got added in, that Scott Robert Maxwell thing. We're going to take a big hit for this. And it's just ridiculous. You guys are, the IG is, and it was in the paper, but it was a lie, are prosecuting a gentleman for $100. It's not $1,000. I was told $100 straight out when that first came. And now we have somebody on the other side who's been bad, in keeping with Corruption County and why we are all here, and just a little slap on the hand. It's incredible. I just can't even believe, I feel like I'm in an alternative universe. You know, it's like no means no, but that just doesn't make any difference. If you can't keep up with the meetings, you're doing what you want, when you want, how you want it. And that's called like a king or an oligarchy. And that's not the way we do this. And it's just so sad to see that all of our time is just so wasted. This is abusive in a large way that we have to struggle to get here, to fight, to go ahead to have your own group of people here vote on one thing that they want to use. Even the people in the back are saying, yeah, and then doth an email come, we shall use this other form. Well, it's just really wrong from every space and place. We are not that easily manipulated. We are not comfortable with this. And we're just telling everybody that we absolutely can, because this is just ridiculous. It's a waste of our time. It is not anti-corruption. This is Cover the Corruption group. And it's obvious. It's written on all your foreheads. It's in all of this. And it's just so sad that at our expense we get another layer of bureaucracy. And we're not even getting a little bang for our buck. With somebody asking to be reimbursed for something is just a scare tactic, so people won't step into that arena. And we must. We see what's going on all over the place, and we must step into the arena. The waste is over the top. Thank you.
Ms. Larson?
You know, I try to be as patient as possible. I have been called a legal terrorist. I have been called so many names in this county. I'm going to start wearing a T-shirt with every moniker on it. The other day I was told I was caustic by a county commissioner. Every commissioner, I'm going to tell you a little secret. Every commissioner who ever yelled at me, threatened to throw me out a window or whatever, went to jail. So I guess the caustic guy better watch out. The voters voted on certain language. Every neighbor I talk to, and I guess you want to ignore us. I don't know. I'm not sure, but there was language voted on by 73% of the voters. Now, granted, it wasn't 100% of Palm Beach County who voted in this election, but this dilly-dallying with the language is unbelievable to me. When I see... I'm going to tell you a little history, because somebody mentioned in one of their emails that they wanted to follow the DOD. Well, let me tell you about the DOD. Let's go back to September 10th, 2001. Mr. Rumsfeld and the DOD had lost $2.7 trillion and didn't know where it was. That was before September 11th. I'm not kidding. This is I can go get you the little speech that he was making on CNN. This is stuff that I don't want to follow anybody else, because we're here because our commissioners were corrupt. Not the staff, not the worker bees, our commissioners. And let me tell you, the very first time I went after the very first commissioner who was indicted, I asked for some stuff. I did a public records request, and they sent out their lieutenants to deal with me. I can't believe it. Please pay attention. I'm begging you. The voters, I've asked all my neighbors. I've tried not to bring them here because you ain't going to like what they say. I'm really nice compared to my neighbors. I mean, I can't repeat their stuff. They voted on the language. Everybody read that first paragraph, guys. I'm not kidding. That's what they voted on. Dave, God bless you for being out there. You know about elected people and how we are. What did we read when we voted for this? The very first paragraph. So please, stop messing with it. Keep whatever language we voted on, put it back there, leave it there, and we'll be done. I don't think the public expected us to be playing with this language at all. They read the first paragraph, guys. Be realistic. Thank you.
Thank you. Mr. Zaks?
I'm Paul Zaks, Chief Assistant State Attorney. I'm just here to make sure everybody got a copy of Mr. McAuliffe's letter, and I'm hoping it'll be read into the record at some point or somehow be made of the record, part of the record. Having been involved with the grand jury that initially investigated the corruption and the ethics in this county, along with Al Johnson. If anybody wants any questions answered, I'm here to help, but basically Michael's position is well stated in there. Any language that circumscribes at the front end what the IG can look at, we're opposed to. I conduct a lot of investigations. You do not know until you're into the investigation whether it's done with intent or not. And I point that out when you're considering the language. Thank you.
Thank you. Ms. Scheibel?
Before I start, I would ask also that that be read into the record in the meeting as opposed to just filed. I sent you all an email last week as well, itemizing my concerns about the timeliness and how this is progressing. Don't really want to readdress what I said in the email, but I did want to talk about Ms. White's memorandum, which I appreciated the extent to which she went and isn't here to hear it, but to the extent that she gave her rationale for things. One thing that was incorrect in her memorandum was she misunderstood funding entity. A funding entity is a government entity that comprises 25% or more of the Office of Inspector General's budget. So any little municipality, big municipality, if it doesn't comprise 25% of her budget, is not a funding entity. So when we talk about removal process, when we talk about any of the other things in there, that is the definition of funding entity, unless you're going and changing it, which to my knowledge you haven't done. Totally disagree with the section on Special Inspector General. It's creating a bureaucracy. It's crazy. If Ms. White had found another organization that used it, I'm sure she would have cited a reference for such a special investigator. You're telling the selection committee what to do, you're telling them how to do it, and you're creating a bureaucracy that's unacceptable. And the removal process, I'll continue to restate that we intentionally made it difficult. We wanted it to be more than just the selection committee. We wanted it to be the funding entities, supermajority, as well as the selection committee. That's not 38 municipalities. That's no more than 5 organizations, because it would be the county, the funding entities, plus the selection committee. So it's not multiplied by however many municipalities or other governmental entities with which the Office of Inspector General goes into contract. Thank you.
Thank you. Mr. Ostrow, Harold Ostrow.
Good afternoon. My name is Harold Ostrow. I'm the past president and honorary chairman of the Voters Coalition. The Voters Coalition is a civic organization made up of, it's a nonpartisan organization, and the membership consists of people who are activists in various communities throughout Palm Beach County. We are an active, influential organization. I sent each of you an email several days ago, and I want to read it into the record, so bear with me, please. We, the people, in order to form a more perfect county, have spoken. As a matter of fact, an overwhelming 73% of voters spoke and will surely be very upset if elected officials or those under them do not heed their wishes. And when voters get upset, they remember those who ignored them, and they will act accordingly. We, the public, want to retain the IG and ethics ordinances as originally drafted, with only changes that are necessary to incorporate the cities. The language of the charter amendment was clear and understood by the voters. We will be unable to restore faith in government if there is a continued effort to weaken these ordinances. Efforts to reduce the role of the Inspector General are contrary to the wishes of Palm Beach County and municipal voters, and are unacceptable. As has been insisted by other members of the broad and influential Ethics Initiative Coalition, and let me point out the Ethics Initiative Coalition is made up of the strangest mixtures of partners that you can possibly imagine. Liberals, conservatives, right, left, north, south, you name it. It's a people's voice, no matter where you think it's coming from, whether it's the business community, the condo community, whatever. And they have made it very clear on a 3-to-1 vote that you must continue to use Cheryl Steckler's draft, which is close to the original. Please limit modifications to those that are absolutely necessary to cover the cities. If you do, the committee should be able to complete this draft very quickly and maintain its original intent, which is what the voters expected. It is up to you, and the voters will remember you. Thank you.
Thank you. Good timing. Perfect. Mr. Scheibel?
Was that the fire alarm?
No, you're fine. When I start moving, start moving.
I'm Fred Scheibel, Palm Beach Gardens, Taxpayer Action Board in South Florida 912. I sent you all a memo, or rather an email this morning, but you probably haven't seen it yet because it just came out. Oh, you did? I won't have to read the whole thing, but I just wanted to say that I did review Ms. White's draft, and, it's not a rewrite, and, a lot of things she says in there I think make a lot of sense. It does clarify. But there are 4 things I think that are indeed problematic from my point of view. One has to do with the notification of the IG on actions by administration. It seems like if you're not required to notify someone whose job it is to look at those things, you basically encourage shopping around for a venue. I don't think that's a good idea. On page 7, regarding the completion of investigations, justifiable reasons is not really defined. And that would say then, well, who says it's justifiable? And, where do you go for that answer? That would seem to be a problem. I think if you just made it notification instead of justification, that would probably get around the problem. On page 9, about the special inspector generals, I think Iris talked about that a little bit. Quite frankly, the selection committee should have their own discretion about what to do. The ordinance shouldn't say that they have to, on every complaint, go appoint somebody to investigate. That seems excessive. And on page 9, about the removal, I think Iris mentioned this too, the 25% funding entity, I think, is key. Perhaps the way around that, now that you have 38 additional entities, is perhaps the league could act in a case where more than one city, or maybe even a single city, if it went to the league, which represents more than 25% in total, maybe that would be the way to implement that part of the ordinance. So, thank you.
Thank you. Ms. Stella Jordan, I'm sorry.
Thank you. I'm Stella Jordan. I'm a resident of and counselor for the town of South Palm Beach. But my comments today are personal concerns as well as those of numerous constituents within my city. Firstly, I support the Office of Inspector General, and I fully support those editorial comments made by both Trila White and Claudia McKenna. They are not rewriting. They are simply attempting to clarify this ordinance. At this juncture, we must define. It's inherent that we define exactly what the definition is for those review contents. Otherwise, we are going to spend much time and money down the road. That would mean that while it's in there that you assist us with economies and efficiencies, we will actually be spending more money and we will be less efficient. So we don't want to waste time because the time, that's the dollars. That's the dollars that every taxpayer pays. Next thing I want to address is that of an addition that I think is vital. It's to avoid any duplicity of efforts. We have a state ethics commission. They do an excellent job. My town has evidenced this by the outcome of a particular situation. We also have the State Attorney General's office. They do an excellent job. That's been evidenced recently by the outcome of the results of 4 of our county commissioners. We already pay for those with our taxes. See where I'm going with this duplicity of efforts? It's also duplicity of dollars, our taxpayer dollars. To avoid this duplicity, I propose a section, that section 2-421, have an addition. That's the section on applicability. I recognize this section is now being redrafted by Lenny Berger, and I'm not sure I know Lenny Berger, so if you're here, you're Lenny Berger. Hi, Lenny Berger. I'm Stella Jordan. Okay. This is the appropriate time to address this issue. What I recommend is that we put in like item 4, which is that at no time shall an investigation be performed if such action would replicate efforts already in place or resolved by either the State Commission on Ethics or the State Attorney General's office. Remember, all we do is funded by our taxpayers for our taxpayers. Our constituents need to understand this. They need to understand what their dollars are going for. That's why let's get back to those definitions just a moment. That's critical. We must define exactly your area. Okay.
Thank you.
Thank you. I will make myself available to anyone, especially you, Lenny. I'll give you my phone number to discuss this further at any time. Thank you.
Thank you very much. And the last speaker is Martha Webster.
Thank you for giving me the opportunity to speak. I'm Martha Webster. I'm the Vice Mayor of the Village of Royal Palm Beach. I'm also on the board of the League of Cities. Stella has pretty much done a good job. Congratulations, Stella. What I really wanted to say is we're on the front end of this, and this is a very formidable undertaking to put it all together, and that doing the right thing here and putting it together in the right way up front, I think, is advantageous to all of us. I particularly am asking also that you look closely at the definitions so that they're clearly defined up front so that we as municipalities understand what our parameters are, because we're here to work with you. We are in concert with this effort. We did vote for it, and we would like to have clear definitions, particularly on mismanagement, waste. They tend to be ambiguous, so if you could help us out in giving us the correct direction in the document. Also, from our perspective as municipalities, it's mine and I'm sure it's everyone else's, that our budgets, little numbers can be budget busters in these economic times. And we're already talking about expansion of this program through employees. And it would come about only once a year. And we would like to have well, we simply don't want to be surprised by what our proportion is going to be toward it. And I don't know how that can be considered in this document. I'm leaving all of this in your hands. You're the experts who are doing a good job. But I did want to share with you where we are from the municipalities. What we have to do, we want to clearly know what it's going to cost us. We want to know as well as possible to take back, because our taxpayers are paying for it both as county, through the county and through the municipalities. So if you will help us out, I look forward to working together with you. Thank you.
Thank you. Okay. We'll need to decide which draft of Ms. Steckler's draft ordinance we would prefer to use today. I had anticipated that we were going to be using the February 9th draft, which was the draft that was included in the agenda packet. It's certainly the one that has all my notes on it. But we've been handed a version February 4th this afternoon. Yes.
I'm okay with the February 9th. It's just there's some language in here that's not mine. So as long as we can address that, I'm okay with using this February 9th.
Okay, great. That'd be great.
Okay.
Okay.
Just the 9th.
Yeah, it's getting...
I got the 17th. I got the 4th.
All right. The memo of the version on the 17th is Trilla White's version of the ordinance with her suggested language changes. She removed edits, so she actually inserted language as a discussion point, and then there is also, you should have an accompanying memorandum from Ms. White, also dated, I think, the 17th of February. We also have received reports from Mr. Berger. That was with a draft date of, or a date of February 9th. I would ask that you have that handy. And then the last item that we received as part of the agenda packet was a memorandum from the City of West Palm Beach, and that would be from Ms. McKenna, and I believe the date on that one was February 17th as well. Then today, we received the letter from the State Attorney's Office, which I would propose that, I know it's been asked that we read this into the record. We can do that at the point in time during the discussion when we talk about whether or not we're going to insert language in the ordinance for definitions. So we can, if we can put that aside for now, we will do that, and that way it can be read in the record in context. Then we also have comments, the email that we received this morning from Mr. Scheibel. Some of you may have it, some of you may not. I was able to grab it on my way here. But there are some comments here as well. So we'll do our best to try to weave these documents together. So if it's acceptable to the committee, we will then work as our base document the draft from Ms. Steckler dated February 9th.
If I could get a If I could get a copy, Tammy, of that. I think I grabbed the wrong one leaving the office today. I think I grabbed the one from February 4th.
I have another one, too, if you need it. I have a color-printed one, maybe.
Well, this one's the 4th. Oh, this little one? Okay. Thank you. Okay.
Can you, that is the 9th, even though it doesn't say the numbers on it.
No, I don't have another copy. Oh, here. Here you go. The color's a little funky on it. It's a little different, so we'll have to, but it is, that should be your version. Huh?
I have an uncolored.
I suspect it was probably an inkjet ribbon or printer running out. Okay. All right.
Do you have a copy?
I do, right here.
All right. Okay. So does everybody have a draft version dated February 9th, 2011 from, that says IG/Steckler's edits at the top in varying colors, but it's the same thing. Yeah, and it appears that as we printed these in our mutual printers, there are different colors that generated from the Word document, so that'll make us even more challenged. What I would recommend we do is, as we review the documents, reference the line numbers, and then that way we can deal with it hopefully that way. Beginning with the issue under what I'll call line 7 through 10, there is a revision from Mr. Berger under section 2-421, and that's title. And Mr. Berger, in his memorandum of February 9th, modified the section so that the new title would read title and applicability. And he inserted then a subparagraph 2 in that defined and I think accurately reflected the discussion that we had at our last meeting. So if that is acceptable, let's plug it in and move on.
I'm sorry. Are you saying the whole section?
Section 2-421 as amended with Mr. Berger's memorandum of February 9, 2011. And that has now 2 subsections. The first section is the same language that's in the code that's presented to you. The second is the Palm Beach County Office of Inspector General shall apply to the following. Subparagraph A, or subitem A, the Board of County Commissioners and all county departments. B, 38 municipalities that approved the charter amendment in the countywide referendum held on November 2nd, 2010, And C, any other public entity that elects to be bound by this article by entering into a member of understanding or other agreement in accordance with Section 2-42310.
One comment.
Yes.
What I don't see in here is for contractors and entities that have money, county and municipality money, there's no nexus here for them to comply with requirements of records and things like that. So I ask that we look at that issue, and we don't want to exclude the very people that we're going to be looking at.
Would that not be as a creature of the municipality or the county in terms of any activities that they would have with those entities, those companies? Wouldn't that be covered under their basic jurisdiction? I don't know the need for that, but.
The subsection is to address the governments that are subject to the ordinance. And because the governments are subject to the ordinance, all of the entities that do business with the governments are covered, which I think is in somewhere in 2-423, probably in several places, or at least it was.
Right.
These are statements of jurisdiction,
Right.
really, not
Right.
applicability.
Right, applicable. Yeah, I understand.
Not who you have to answer to. Our view is that you get to follow the money wherever it goes.
My concern is that we're labeling those entities, and the language within the ordinance speaks of it, but this is the applicability. It's silent. So I don't want to have to be going through court and other reasons to try to get records from our vendors when they say it doesn't apply to me because your title and applicability doesn't cover us.
I think that by comparison, another countywide ordinance that's familiar to all of the cities is impact fees. Every contractor has to pay an impact fee. It only applies to the cities because it's questions of jurisdiction to the government. So again, it doesn't reach every single person that's affected by it, but everybody that does business with or within those cities has to be covered.
Yes.
Thank you, Mr. Chair. Lenny, I thought that we had expanded it to any new municipalities. I thought at the last meeting. This language says that the new municipality would have to voluntarily opt in. They're not automatically covered by it.
There is other language in the ordinance that would allow for that, or that can be under subparagraph C. That still is a municipality is still a public entity, so they could opt in that way.
Right, they have to voluntarily opt in, though.
That's correct.
So if a new municipality is created, they're not automatically included in this.
Interesting question. I don't think so. I think they would have to have their own referendum.
Well,
what's the likelihood of that
not
happening?
necessarily. By law, certainly, because of the referendum, this applies without question to these municipalities. By existing language that is in our charter today, we could make this countywide, which means it would apply in any new municipality unless the new municipality adopts an ordinance that conflicts with it. So we could reach a little bit farther, and you can't just adopt an ordinance saying that the countywide ordinance doesn't apply, because that's been held to not serve a public purpose in a different context. So a new formed municipality would literally have to have their own inspector general to have it not apply. So if you want to go to that length, we could add that in here also.
I guess that's up to the committee. I'm comfortable with the language the way it's written.
So just a point of clarification, you're saying this would apply to the new cities if one were created today or after this is adopted?
We would have to make it plain in the language of the ordinance that was the case. We'd have to add another line saying that it would apply in any other municipality that doesn't have an ordinance in conflict.
So the way it's written now, it won't apply to a new city?
Correct.
Okay.
All right, well then.
It's all how you ask the question.
All right, is there direction to Mr. Berger to provide a further amendment to the language that would deal with the possibility that we have a creation of another municipality?
I would think that cities now and in the future, if they're covered now, any new ones would come under this. So I would think that we would want to have some language in here to clarify that.
Okay.
I'll second that.
Okay. Any further question on that? Okay, all those in favor?
Aye.
Okay, Mr. Berger, you got a little more work to do then on that language. So, Okay.
Just one more thing.
Yes.
In getting to Ms. Jordan's comments about adding a section in here and talking to Lenny and giving her phone number. I don't think based on the
Jordan, you're up.
discussion. No. Well, that this particular location would be the place to actually insert that kind of language. But that if there was some other investigation or work that had been done by another entity, that it would not see another swipe at it by the Inspector General. It would be in another section of the.
I think it already is, too.
Yeah.
Okay. So I just wanted to clarify that.
I thought there was language that there's an ongoing investigation or the process that that would be coordinated to make sure there isn't two bites at the apple.
Well, there's not two bites concurrently, but there's not consecutively. After an investigation's done, theoretically, you could come after it. Now, I don't want to discuss it under this section if it's not appropriate, but
It's not under this section if you want to wait.
So
We'll wait.
let's move on then into when we get into that realm, then we'll talk about it.
Thank you.
Okay. The next section is 2-422, office created and established, and that would be lines 12 through 25. In this instance, there was some language from Ms. White's ordinance, which I didn't see any significant changes at all. I think we've got a match here.
Yeah, we already passed this last meeting.
Right.
Okay.
There have been no
Okay.
changes to it.
Then we deal with what I'll call line 26 in the ordinance, and that is whether or not the committee wishes to discuss a new section called definitions that would be inserted into the ordinance, presumably at this location. Now, we have the report from Ms. White. The draft definitions are on lines 44 through 78 of the Trello White draft. And we also have, it is also discussed in the memorandum as well. We have now the letter from the State Attorney's Office that is taking a position opposed to the establishment of definitions as I scan the letter, so that needs to be discussed and read into the record as well. I'm not going to read it into the record, but I'll ask somebody else to do so from staff.
Would you like me to do that?
That would be great, Mr. Merriman.
This is my Oscar moment. Glad I brought my reading glasses. Kurt Bressner, Committee Chair, Inspector General Ordinance Drafting Committee, letter dated February 24, 2001. Palm Beach County Inspector General Ordinance. Dear Mr. Bressner, I have reviewed the various proposed amendments and changes to the Palm Beach County Inspector General IG Ordinance. I understand that the drafting committee is evaluating the proposed changes to the ordinance today. While many of the proposed changes are appropriate to expand coverage of the IG to the municipalities, two of the proposed changes, if approved, will significantly hinder the work of the IG and are not appropriate. A right to communicate my concerns as your state attorney and as an advocate of the original ethics reforms as the expanded coverage of those reforms to the municipalities. The proposal to define the terms fraud, mismanagement, waste, abuse, and misconduct, while well-intentioned, is fundamentally flawed. The definitions appear to be drawn from federal institutional IG offices which can and do undertake criminal investigations. In Palm Beach County, law enforcement and my office perform such criminal investigative and prosecutorial functions. While the Palm Beach County IG, its PBC IG, certainly must have initial jurisdiction to examine such activities for potential criminality, if an issue examined has the potential for criminal prosecution, is referred to my office. As such, the emphasis on and use of definitions that require intent or deceit miss the mark. Such actions are always included in the terms waste, fraud, and abuse. However, the definitions appear to require such criminal intent, i.e. requiring, quote, conduct undertaken with the knowledge that conduct violates, end quote, or designed to cause the loss, end quote, excuse me, I missed, there's an open quote there, for IG jurisdiction. What starts out benignly enough quickly becomes a severe limitation on the ability of the IG to autonomously and independently examine any potential issue regarding waste, fraud, abuse, or inefficiency. More importantly, the proposed definitions lack an exclusionary language, tack on exclusionary language such as does not include action or inaction, which is inadvertent, unintentional, or insubstantial, and does not include management decisions which are merely debatable. This component of the proposed definitions will hamper and impede the work of the IG. By including broad exclusionary language on the front end of what the IG has jurisdiction to review, the IG's value as an independent watchdog is gutted. Moreover, the fundamental problem with the definitions are exponentially compounded by the proposed section requiring special inspectors general to be appointed to review the work of the supposedly independent inspector general. See proposed section 2-433, selection and responsibility of special inspector general. The trigger for such appointment is any complaint alleging a violation of the terms of this article. Upon any complaint, the selection committee, on which I serve as a member, shall appoint a special inspector general. Whether intentional or not, the proposed section creating a special inspector general results in a needless layer of bureaucracy and gives all covered entities and individuals the basis to interfere with the work of the independent inspector general. All one has to do is file a complaint that the independent inspector general is acting outside the proposed definitions of fraud, mismanagement, waste, abuse, and misconduct, and a special inspector general must be appointed to investigate the investigator. Pointedly, the provision creating a special inspector general is meritless and may prove fatal to the IG's mission. The provision eviscerates the very heart of what an independent IG does: examine potential issues of waste, fraud, abuse, or inefficiencies in government without hindrance or interference of the covered entities or individuals. A basic understanding of the role of the Palm Beach County Inspector General persists. The Palm Beach County Inspector General does not and cannot hire, fire, demote, or discipline any employee. The IG cannot change or mandate any policies of any of the covered entities. The IG cannot charge any individual with a crime. The IG's purpose and power resides in its ability to examine, evaluate, and recommend with independence and autonomy. The IG's power is in unfettered evaluation, reporting, and persuasion. Nothing more is needed in an IG, but nothing less is acceptable to the community. I trust that the drafting committee will act in deference to the progress achieved over the past almost 2 years and in recognition that 72% of the voters in Palm Beach County resoundingly approved the expansion of an inspector general to act as an independent watchdog over county and local government. I'm available to address any questions you may have regarding the issues. Sincerely, Michael McAuliffe, State Attorney.
Well done.
Thank you very
well
much.
Well read. All right. I'd like to turn it over to Ms. Ashton, if you would like to offer some comments regarding the proposal from Ms. White as to the inclusion of definitions into the ordinance, please.
Sure. Thank you, Chairman. Ms. White and I did help her with this. We did a lot of research out in the Inspector General world, and Ms. Steckler was absolutely correct in saying originally that Inspector Generals commonly look at waste, inefficiencies, fraud. That type of language is very commonly found. What we also found was common were definitions. And we took these definitions specifically from, I think, the Department of Defense and one of the Air Force departments. And the reason we picked these was not because we thought the Department of Defense or the Air Force was the best departments in the federal arena, but these definitions seem to sum up other definitions that we had found when we did our survey of what departments that have inspector generals actually include. And To address some of Mr. McAuliffe's concerns about these definitions, he's approaching this from a criminal perspective, but Trila and I were approaching this from a civil perspective. I've been a civil litigator for many years. Ms. White has experience in the civil litigation arena. And if we come into a situation where a city or the county takes the advice of the Inspector General and takes some action, a disciplinary action, fires an employee, lets go a vendor, something like that, the city or the county could find themselves in litigation. And Palm Beach County is very litigious. I can guarantee this is going to happen at some point in time. If a city or a county gets pulled into litigation, you're in a civil court at that point, and you are going to be required to prove fraud, abuse, misconduct, mismanagement, or waste pursuant to a civil burden of proof. Now, that is difficult if we have no instruction on what those terms actually mean. And I understand the public has been concerned that, a common person, a normal person understands exactly what those terms mean. That's all well and good, but in a court of law, that doesn't always work. There are very specific standards for proving things. There's specific definitions for proving things. For example, fraud is very specific in the civil context. In civil court, you usually have to prove that somebody misrepresented something to you. You relied on that misrepresentation, and you suffered damages as a result of that misrepresentation. I think probably the Inspector General will be looking at things much broader than that limited civil definition of fraud. And that's fine. That's part of the reason we included these definitions, and they are broad. But we did approach this from a civil perspective, and to give our cities and counties some protection in the event they did get sued. Also, it's helpful from an administrative standpoint for our county and city managers to know what types of conduct they should be looking for from their employees. If there aren't any standards, it leaves everything to be very, very subjective. And one county manager or city manager might think something is waste while another would not. So if we could give some guidelines, some parameters to what kind of conduct is prohibited, I think that this would make the ordinance better overall. To address Mr. McAuliffe's comments about intent or deceit, I want to point out that the waste definition, I don't see any intent in that definition. It would cover negligent or unintentional actions. And I think that is the waste definition, along with the mismanagement definitions, are the two that are probably the most vague and ambiguous and most difficult to decipher how far those definitions extend. But I did want to point out that the waste definition does not have an intent component, and that is because probably waste would include a lot of negligent acts, more unintentional acts. So that definition does not have intent. Fraud, you have to have intent with fraud. It doesn't exist in civil court if you don't have intent. The abuse definition has both intentional and unintentional. The definition says abuse means the intentional, wrongful, or improper use of rank, position, or authority. So that would include both intentional and unintentional acts. I don't need to go let's see. Misconduct could involve both unintentional and intentional, depending on what it is. Mismanagement can include both. Misconduct would probably be more along the lines of an intentional act. Ms. White, in her memo, addressed the language at the end of the, make sure I get these right, the mismanagement and waste definitions. There is language that says these terms do not include management decisions, which are merely debatable, nor does it include action or inaction, which is inadvertent, unintentional, or insubstantial. The reason we originally decided to put this language into the definitions was because we didn't want a situation to arise where the Inspector General says that the city manager should have chosen Chevys over Fords, and I think Mr. Bornstein had brought that example up at one point. We didn't think that those were the types of decisions that really should be made. It should be more things that are, extravagant expenditures, constant misuse of money, things along that nature. But Ms. White and I talked about this before I came, and we're not bound by this merely debatable language. We thought it was interesting language. It may address some of the concerns with those two definitions, but we're not bound by it. If it's the pleasure of this committee to eliminate that language, that's fine. I did want to point out that the inadvertent, unintentional, or insubstantial language comes from the Commission on Ethics. A complaint under the Commission on Ethics can be dismissed if it is inadvertent, unintentional, or insubstantial. And I think that that might be a good guideline to have here too. If the Inspector General finds that there was waste, say somebody took a pen from a cabinet and took it home, but that's really unintentional and inadvertent. That's not something that should be taken through a full investigation. So that was our thinking behind these definitions, and I hope that everyone understands that these definitions will not prevent litigation, but they might help us defend litigation, because it will happen, it will come. What form, I can't tell you, but anyway.
Okay, thank you. Other comments from the committee, and I have a comment.
Mr. Chairman?
Okay.
May I? Thank you. A few observations. First of all, I too agree that I was impressed with the thoroughness and care of the writing and research done by Ms. White and Ms. Ashton in arriving at these definitions. I don't know that I would ever have found some of the resources that they were able to locate. But I have a couple of thoughts here that I want to share regarding Ms. Ashton's comments. First of all, whether or not a municipality or the county or any other covered entity decides to institute civil litigation with respect to findings of the Inspector General are not within the jurisdiction of the Inspector General. Those decisions are made at the local level by the local government, considering the recommendations and report of the Inspector General as to what actions they'd take. And I'm sure with the level of competence of the local attorneys that I have met in Palm Beach County advising the cities, all of these issues would be vetted by those commissions when these issues come up, whether or not the actions that were, whether or not the actions or inactions that were uncovered are merit a civil suit or not, will be a decision of those cities. A couple of thoughts there, and therefore, for that reason, I see no reason to go into some of the issues of inadvertence or merely debatable or any of that. Secondly, when you look at the definitions that Ms. White and Ms. Ashton proposed, there is many vague terms in there, more actually, vague terms in those definitions than there are in the vagueness of the words mismanagement, waste, and the other terms that we're dealing with. So I don't really think even if we chose to follow the definitions, I don't think we've added very much certainty at all. And in fact, instead of adding certainty, I think we've also created uncertainty. The role of the Inspector General is to look and look again and look as far as the Inspector General needs to look to find the items that create expense and loss in the conduct of our government. They shouldn't be stopped by any barrier because they might find nothing when they look beyond where they're looking. Even in those instances where there is something that a city or county may determine is not a basis for civil litigation, it may be something that they say, why, how did we miss that? Why don't we change our policy? Why don't we change our procedure? Why don't we change our ordinances to see that this doesn't happen again, even if we elect not to take any action against anyone who may have been involved in it? So I think while I appreciate that these are fine definitions, although I do believe that they add some uncertainty where there is less uncertainty now, I don't think they're necessary. I think they limit the scope, limit the things that the Inspector General can look at, and I think they should remain as they were in the original Inspector General's draft. Thank you.
Mr. Chair?
Yes.
I'd like to offer my comments on this being one of those dreaded city managers that works in local government. We in government willingly and with I think, a sense of public service. We go into these jobs knowing it's a politically charged, difficult environment to work in. We operate in a fishbowl. Everybody looks at us, and many times, how about all the time, we're constantly being barraged with the politics of situations, of issues, and you try your best professionally and through standards that we hold and all the rules that we have to follow, constantly manage our resources to the best of our abilities. A lot of times with conflicting direction over, we want you to do all this, but we want you to save money, and they're this constant. The policy boards that we work for, as much as people dislike and loathe politicians, most of the ones it's been my fortune enter these jobs willingly with a sense of public service, and most do the right thing. There are the exceptions. But they work in a very politically charged environment. The mere presence of an inspector general to show up on a doorstep for any reason can, and I'm not sure this is not the intent, can cause those of us in this environment that's very precarious to lose our jobs, to lose elections, to do a lot of things. Not that you find anything, but in this environment we live and work in today, just the mere presence of you showing up to look at something that somebody complained about because they have a political bone to pick with this person or this entity, and you show up on the doorstep, you're automatically presumed guilty in the public's eye. And that's the charged environment. And that's one of the reasons I think it's important to have as much clarity, not only for you to not be used as a political tool for someone who has nefarious intentions, as an unwitting participant in that effort to try to get at people they don't like, or institutions or people in the government, but also from our perspective, who work in government. It's important for us to have as much clarity as possible at what you're going to be looking at, because if not, our tendency is going to be to weave a cocoon of policy and bureaucracy around every decision so that our staffs and us, we don't step into any unforeseen snares because we're so afraid to try to act and be businesslike. We get that a lot. Which government is more like business? We are becoming more and more risk adverse because our head's on the chopping block 24/7. That's the reason, I think, and personally, working in this industry as long as I have, think it's so important to have that clarity and these definitions in there. It's not because we're trying to hide anything. It's not because there's something going on. We're trying to. That's been said in the paper. I've read all the emails coming in. So we gladly serve in this arena, and we do the tough jobs a lot of times, and it's what we do. But please give us as much certainty about where we can go and not go without constantly fearing we're on thin ice. That's why I think we need to have these definitions in there.
Thank you. Ms. Steckler?
Wow, a lot to talk about. Starting with Mr. McAuliffe's letter, and in fact he put some things that I was going to talk about, the definitions that we're using, we won't go into too long, but the Department of Defense, OIG, is actually a criminal justice agency, and they do arrests and they do criminal investigations, and so we're mixing apples and oranges. This is strictly set up as an administrative arm. And to kind of go where Mr. Baker was going, again, and I think a lot of this is that the misunderstanding of what the role of the Inspector General is. We are going to shine the light on inefficiencies. We're going to shine the light on mismanagement. But at the end of the day, it is the policymakers, it is the city manager, it is the county administrator that will take the actions that need to be taken. The experience the county has had so far is, we work with their HR, and we give our recommendations, and it is up to the HR attorney and HR and the department director to figure out, based on the facts, strictly the facts of where the case took us, should there be any action taken on whether an employee, and then we make recommendations. We don't recommend what should happen to an employee because it's not our call. But we will make recommendations if you have a weak policy, or if someone is stepping in it because your policy is vague or you don't have any policy at all. We'll make a recommendation That doesn't mean, especially in the political environment, we have a report that's going to be coming out very soon. It is a policy decision. It is a big decision on whether or not the county is going to continue to do certain things, because we have found issues with the way the ordinance was drafted, with the way the program is operating, with the unintended consequences, with potential cost avoidance of where it's headed. Those are things that we just surface. But at the end of the day, we don't tell you, do this. All we can do is recommend to you, this is what the facts are. This is what the people have said, whether it's an employee, whether it's a vendor, whether it's a prime, a sub, we'll get the testimony that will say, this is how we see it. It's up to you all to evaluate that. And before any personnel action is taken, at least I've seen this in the county and I've seen it in my prior experience, the HR attorney and the HR and everybody gets together before any kind of action is taken, and that's for them to do. I'm not a party to that. I shouldn't be, and I'm not, because I don't know whether or not that employee has done things in the past. It's not my call to say you need to be fired. So there's a lot of separation here, and again, it is to make sure, and again, complaints we don't have, with the amount of staff we're going to have, we can't look at every little thing, nor would we. That is an inefficient use of our time. And so we have 3 different levels. We have where a complaint will come in, and it is not what I say is an IG issue. It is a management issue. And we will send that to the management team, whether it's the department director or city manager, wherever we believe it needs to go, that it gets handled. If we get something in where we go, well, kind of, sort of, not really, but we want to make sure that the consumer or the constituent or the employee is got a response, we'll send that as a management inquiry. Now, over time, my experience has been usually about 60 to 70% of those complaints will fall in those categories. Then you'll get, at the end of the day, about 10% that will actually turn into what we'll call investigations or management reviews. So when you talk about every 100 complaints that come in, we may look at 10 of them for a potential review of the program or an investigation on a particular individual. So we don't have the resources and the luxury to just go nitpicking at every little. We couldn't possibly, with 38 municipalities and the county and Solid Waste Authority. We're not this big operation that's going to be out there looking at every little thing. So you have to bring it back into focus. This is really about government efficiencies, detecting where we have issues, and you can read it in the paper every day. Everyone is procuring, everyone is doing contracts, and you can see where perhaps maybe the law's not being followed, or your policy is not being followed, or the county ordinances aren't being followed. That's where we're going to be looking to make sure that procedures are done correctly in accordance to whatever you have written. If your procedures aren't written, we don't have a violation. We may tell you need to write a procedure, it would be good practice, but we won't support something on someone. In our one of the very first cases we did, we had an employee that was out there doing things that, at the end of the day, we did not support it against the employee because the county didn't have a policy. So the county now has a policy. So, again, we won't have the amount of people that when you say we're going to look at every little minute thing. But at the end of the day, if we get a minute thing, and then we get another minute thing, and then suddenly we get 10 of the same minute things, it's going to begin to have a systemic approach. And that's going to be a red flag to us that maybe we need to look there because we're hearing it so many times. So even something that starts out small may, at the end of the day, become very large, and at the end of the day, could become something criminal. We don't know until we go there.
Mr. Chair. Go ahead, I'm sorry.
Well, I was just going, just for purposes of clarity, what are the 3 levels of complaint? Just summarize the 3 of it. What are the 3?
A management referral.
Okay.
A management inquiry.
Okay.
And an investigation / sometimes we'll do a management review.
Okay, good.
So again, going back to the definitions, and there are over 30 inspector generals in the state of Florida that work under 20.055 Florida statute. There are no definitions. There are countless inspector generals we don't define because you don't want to hamstring the inspector general. If they need to look, they need to look. And at the end of the day, we need to let management know if they have a problem.
Mr. Chair.
Anybody else first? Sorry, I meant that in the nicest way. Anybody but Michael.
I've heard that before.
Yes. Okay, you have the floor.
I'd just like to follow up to those comments. Everything that Ms. Steckler said, I completely understand and agree with, but I see it, all those same things covered in these definitions. A pattern that's there, seeing things, this would validate that I don't know, what'd you say, 90% of the calls that you get sometimes are not founded, or whatever statistic you just, this actually validates that. This would give the Inspector General the clear basis for when the resident or someone calls in and says, there's a problem here, and you're not going to investigate it, because you're not going to be able to investigate everything, either because of resources or in this case, I'm saying because the definitions back up your decision process. I think this mirrors what you're doing, and I can't see the conflict here and why this is such a sticking point.
These definitions are criminal intent, knowingly, and as Mr. Baker said, how do you define extravagant, careless, needless? I mean, you can throw out all these languages, these words here that you start to hamstring when you start trying to, I mean, we'll be forever trying to define what does all that mean, and you'll never get the job done. And again, it doesn't always have to be a continuous pattern. I'm just giving you an example where something minor can suddenly become something large. But these definitions are through the Department of Defense, and it's a criminal justice agency. And if that's where they want to take the Inspector General is to become a criminal justice agency, then these definitions you could start to begin to talk about. But that's not what this, at least my belief is that this is not what the IG's office was set up to be here. It was set up to be an administrative arm.
Well, then there's got to be some way to craft something to give the people in local government a better direction on what you're going to be looking at or not looking at. I think that would be, if it's not these, it needs to be something.
May I suggest something? There might be another path here to get to what the managers may need, and that was why I asked in terms of the defining the 3 levels of complaint, and whether or not as part of promulgating those administrative procedures and regulations, just as the police department prepares standard operating procedures or general orders, that could provide a definitional framework that can provide information and basically publicized well in advance. I mean, when you're a police officer, you sign the general order, and you sign that you have read it, you understand it, and you're going to be bound by it. And whether or not an approach here can be that perhaps as an alternative to putting the definitions in the ordinance itself, if there can be a set of standards or definitions or criteria to better identify from a management point of view what we as managers need to have our Doppler radar turned on for, and to basically, I know our mothers and fathers put us on this planet with some basic ethics, and understand that. And I understand that we have some core responsibilities of that, because that's why we're good city managers, is we try to maintain that. But I think from a point of view of providing some guidance to the managers and subordinate staff, something along those lines may be beneficial.
With respect to the law enforcement, many of them are accredited, just like this office will be going through accreditation. The standards currently exist, but there is no standard that is required of a definition of what the Inspector General will look for when it comes to waste mismanagement. I mean, the very same commission that certifies the police departments also certify us, and at present time that does not exist. And we do follow very much the written directives of those standards, and will be going for accreditation. And it outlines all the other issues that are brought up with time standards and things like that, but it makes it very clear that we go in where we need to go, but there's not a definition stage in that at all. Or the Green Book.
Yes. Wait a minute, Jennifer.
No disrespect to you. I keep hearing about standards. I follow standards. If there are specific standards, why cannot those not be in the ordinance?
They are. They're actually part of my recommendations that we're going to be going forward.
I mean, I read yours. I didn't see anything about complaint investigation or anything like that in your additions. So if there, like Mr. Bresner was saying, if there are procedures you use, then that could give clarity to the process, and I think those things should be included in the ordinance to let people know what you are going to be doing.
Would you put every procedure you use in the city in an ordinance that would have to go through a vote every time when you needed to change it? No, you wouldn't. So that's why we put the standards into the ordinance as a recommendation, is that we follow the standards, because the standards then outline what those procedures
Maybe
are.
not everything, but at least with respect to your procedures that you follow with when complaints come in. I mean, we don't know.
And again, if accreditation standards change, you'd have to come back here every time
But how
and
often
change
do
the
they
ordinance.
change? I'm just
They
curious.
could change every 3 months, depending on the accreditation. I mean, you all have police departments. You know how much they go and they change those. They'll make slight changes. They'll make major changes. Just depends.
I'm just having a very difficult time with this because if I go to my cities and I have a workshop with them and they say, tell us what the Inspector General is going to be looking for so we can police ourselves and we can get ready. We can try to clean things up before she comes in. No, seriously.
I'm sorry.
If they say, well, what does waste mean? I don't know. I mean, I can kind of give some examples, but I don't know how far you're going to go. I don't know.
When you say clean things up, I think that triggers a lot of people's concerns.
Well,
Okay.
not clean things
Time
up.
out. Time out. Time out.
It was a poor use of words, but I think my thought is valid.
One of our earlier conversations regarding this ordinance, we did ask Ms. Steckler to include language in the ordinance that would reference standards, which that has been done. But I think what you're hearing from some of us is that whether or not it's included in the ordinance or whether or not it's included in some set of standard operating procedures, whether or not there can be some additional work done on some guidelines that would assist the municipalities to making sure, going into this, that they understand what they need to be watching out for, not in the sense of making sure that things get squared away so that an investigation can't happen, but rather to make sure that we're all talking the same language and we all understand basically what the rules of the road are. I don't know if that's an unreasonable request, but I guess I'm running into the prerogatives of the investigation, that it's being viewed as something that would otherwise hamper or impede the flexibility, discretion, however you want to describe the approach that the IG may make in an investigation. And I don't think that's what we're saying here. I don't think that that's the issue. We're just asking for clarity here on making sure that going into this, all the municipalities understand as clearly as possible whether it's a set of subsidiary administrative regulations that we are aware of and we sign off on, that would be beneficial.
I think it will be hard in the investigative arena in some respects because we don't know what we're going to be dealing with when we get into the cities. But remember, in an audit, let's switch to audit. In an audit environment, your management team we do an entrance. So you will very much know before we even begin what we're going to be looking at. Just like anyone that has an internal auditor now, it's a similar process. Our managed reviews are a similar process where we let you know ahead of time. But, new to this county, again, I'm not sure what we're going to be getting. And so to try to define for you, watch out for this, watch out for that, is going to be very difficult because between the public, the vendors, the employees, it's a rash of things that we receive. And again, whether we think that it's a minor issue and we ship it back to you, or whether we think it's a major issue that needs to be looked at, we work with management when we can. It's not a hidden secret when we're in a particular department. So it's not like we're rustling in and I'm just trying to explain the process to you a little bit to help understand that, and especially in the audit world and the contracting world. We sit with your very staff when we sit in the contract procurements. So there's no hidden agenda, hidden secret. We tell you as much as we can at a top level, of course, when we get in, especially particularly in the audit environment. But if you have risks that come up, we might not know until all of a sudden we start seeing certain things and you go, this is a high risk for the city. Let's go sit down with the city manager. Let's go sit down with whoever and build some consensus and see whether or not you might think there's an issue there and what we're seeing and whether we decide to open up a review or not, or an audit. I mean, so it's not just investigations on people. There's a whole other aspect to our world, and that's audit and contracting. And so in some respects, you'll know right off the bat because of the way the process works. And many of you who have dealt with auditors know there's always an entrance, there's always an exit, there's always consult in between that process, so there's really no surprises.
Okay.
So that's other
All right,
part of our role.
let me approach it maybe in a slightly different direction. You had asked through the League of Cities, and you had sent letters out to all the municipalities asking for core source documents. One of those areas would be procurement procedures. Do you envision the IG's office having the ability, it's easy for me to ask since you're ramping up your staff now, for the IG's office to, what do I call it, a vulnerability analysis for a municipality so that you can do a quick scan of our procurement procedures, and knowing that there are some standards that are out there that are best practices or other items that you can provide some guidance to the municipalities, just as you said, in terms of the management review. I know that would be on a case-specific basis that you would be able to find something. But looking at things a bit proactively here, whether or not the IG's office is in a position to do some type of what I'll call a vulnerability analysis of the community so that we're able to right the ship procedurally, so that we're kind of given early warning that you could open yourself up to some holes here in terms of misconduct.
One of the things and why the language is important about prevention is that very thing. What we're doing right now, as an example, sitting in on some of the procurements for the county, is every program does it a little differently. And so there are best practices out there that they do, and eventually we will be working and putting a report together on what are some of those best practices. So yes, in response to your question, yes, we can look at it. We can't be part of your process. We can't help you draft it, but we can certainly look at the process and the procedures globally and tell you, based on what we're seeing in your city, these are good things. These are things that are keeping you vulnerable, why you might be potentially getting bid protests. So there's training and prevention on the contracting side.
Okay.
Absolutely.
All right, thank you.
Mr. Chair,
Yes.
we actually talked about
Yes.
that, and that's actually pretty exciting. I guess trying to hone in on maybe what I'm trying to get at, when you're sitting around your staff room and you're planning out your functions for the week, you've got to have a process. You have to have a procedure. You have to have some. How do you discern between a complaint or complaints that are politically driven about an elected official or a manager or whoever it is, I hope there is some standards and guidelines at that level. It's not just, well, it's a slow week and we're going to be down at Lantana at the old Key Limehouse, so let's stop in and see 'em.
Typically,
You know what I'm saying?
Yeah.
Can't you tell us what that is enough to give us?
Well, typically, what we look at is your HR, your discipline rules. If you have a fireable offense or a suspension offense, typically we will look in that arena. If it's just something that's, a verbal, especially with the caseloads that we expect to have with the staff we have, we're going to be measuring, and then again, it's going to be per city. One city may say, I need you in here for these particular things. Other cities may handle it very well, but typically right now we look at the merit rules and we look at kind of what the suspension, what level would happen if they did it. Would it mean a suspension or termination? If there's no rule behind a discipline, then that would be something that we would probably guide back to management and say, you handle this issue.
Let's dispel a couple things.
Okay.
We brought up a couple of examples, and I always love to pick on Lois, so I'll use the example of the fireworks that somehow got in the paper. City raising taxes. There's even a disagreement on the board, and maybe one of the board members calls in and says, "This is a waste of money, $25,000." Does that meet your criteria? Is there a criteria that says that's a political decision? I really don't need to look at that.
There's not a threshold where the criteria is if the public already knows and you already know and you're dealing with it. I don't need to get into that. That's a duplication.
So if you followed the budget procedure and the procurement process and you did all those steps right, it's not something you're going to look at then.
More than likely, no.
Well, you're further insulated, too, if it's a legislative decision, that there's been a legislative decision that would basically, it would be one thing if there was the purchasing rules were not followed, and they
Correct.
went to Bert's Firework Company because that was a second cousin. But
understand that.
But if you're going through the process where there's legislative decision on that action, I wouldn't think that that would be something that would fall under the purview.
If there's an allegation that it was tainted, I'll give you another example. Instead of the fireworks,
Not tainted, but the fact.
if it was a clean process.
Everybody's out there. They're in the streets. They're yelling. Maybe even some of the folks that come to this audience saying that was a waste of money. You've got to go investigate this.
No, that's not something we would do.
Well, it's waste. It says. And
But again, the light has already been shined on that issue. You are already addressing that issue. It's when no one knows about those issues and they're not being
That's
addressed.
a level of clarity that needs to be somehow addressed.
I don't know how you address that in writing. I mean, it's just.
We just did it.
You know, Mr. Chairman.
Go ahead, David.
Thank you. One thing that's fascinating about this process, and when, several years ago when we first started talking about this, we said, if nothing else happens, at least everybody will be talking about ethics. I think we're there. I think the perfect example is one that you used, Mike, and that's are you going to criticize people for buying Chevys rather than Fords? Well, maybe. Depends on whether the Ford dealer's on your board. It depends on whether the Ford was $1,000, $2,000, $5,000 per unit more expensive and didn't meet the specifications. I think the issue here is that the problems that are being proposed are not necessarily black and white, although the one you did raise probably is pretty black and white. And that's the fireworks. I mean, as the Inspector General has said, this is to shine lights on things. If the light's already blaring, as it is, particularly when you have a mayor's race in a strong city, if the light's already glaring, you don't need to go raise that issue. But when you get complaints, and I'm not naive enough to believe that there are not going to be politically motivated complaints to the Inspector General. But I'm sure that practically every experienced Inspector General has had politically motivated complaints and can see them for the most part. So I think that while I understand, and I know the fishbowl that city managers and in particular elected officials live in today, and it is an uncomfortable fishbowl, and it is difficult to go out at the end of the driveway in the morning and pick up the newspaper and read what a slug a person is because the newspaper said they're a slug. That happens whether there's an Inspector General or not. And frankly, the State Ethics Commission has received complaints that were clearly unjustified before and has been pretty good at figuring those out and getting rid of them. The Inspector General and the Commission on Ethics won't be perfect. They'll learn just like everyone else. But the baseline for the Inspector General to perform on has got to be broad enough that she can look or he can look anywhere they need to look to help the cities, the county, the entities that are subject to the ordinance do better than they're doing today. And that's what this is all about, just helping the cities and the county do better than they're doing today. And giving the Inspector General as much room as we can to do that job is what this has been about for me and what I think this has been about for most of the people who've been involved. And we thought, and we still think, that the ordinance as we originally proposed it and the charter amendment as was originally adopted by the voters achieved that. Not a perfect document, and we know that. And we are open to criticism where the criticism can improve the role of the Inspector General. Honestly, and I appreciate what Trila and Jennifer have done, I don't think it improves it. I think it adds more confusion, more definitional confusion, more ability to attack and undermine the Inspector General than exists today. And that's just, we don't want to do that.
Well, okay. Well, Yes, go ahead.
No, go ahead.
Go ahead, Donna.
I just had a general question, which is that in those situations where the county or a municipality may not have an ordinance, for example, they may not have a procurement ordinance because there's no law that requires a county, and I believe the same is true of a municipality, to have a procurement ordinance. There are certain provisions of the state statute that apply, like CC&A, but you aren't required by Florida law to have one. Now, the county's purchasing ordinance is based on a procurement ordinance that was proposed by the American Bar Association 20 years ago. But technically, as I said, under Florida law, my understanding is that Florida law just requires that your procurements not be arbitrary or capricious, or be done with favoritism, corruption, et cetera. And the same kind of issue exists with employees. You may have merit employees that have certain rights. You may have another large group of employees who are at will and are subject to termination at will under Florida law, provided that that termination isn't based on an unlawful or discriminatory reason. In those kinds of situations, when you go into a city and you look, and there is in fact no policy or there may be no ordinance, what then is your role?
Well, again, if there's no policy and we see that there might be some liability for the city, we'll recommend that they might want to adopt some policy.
But sometimes the city may not want to adopt
And that's
policy
what-
because a policy can actually limit them in the exercise of their discretion or their will.
Right. Then we will tell the city they absorb that risk.
Oh, okay.
Why is everybody looking at me? I appreciate what Mr. Baker said. You know, our hope from the city side in understanding the Inspector General, you know, corruption, fraud, getting at those issues, not following the proper policies, you know, blatant types of issues that we've seen in some cases, you know, we really, that I don't think there's any question on those types of issues. It's keeping you focused on those and not getting caught up in some of the other areas that are policy or management decisions, and then having you come in as an arbiter and deciding those things for us. You know, that really, that gets at our home rule set of issues. We're not talking about it if we bought the Fords because Joe Bob's got a Ford dealership and he knows the mayor. I mean, hallelujah, go at it. And I think we all should rid ourselves of that type of transaction. It shouldn't be happening now. But getting down to where you're starting to split hairs on, there's 38 cities. They have varying levels of degrees of sophistication and resources. You've got cities that have internal audit committee. You have some that there's one or two people doing the best they can to keep their taxes low because the residents want it that way. And yeah, you can come in and say, you know what, you need to do all this stuff. They already know that. They really do. And they're doing the best they can, sometimes with spit and Balaam wire and some duct tape. That's what we do. And I think that frustration is without having a little bit of an insight to how you're going to discern between what you investigate and what you don't in the political or management arena, the waste and mismanagement, not fraud, you know, not the abuse or misconduct. I think that's where
you know,
digging into those, and that's where I'm having trouble with that.
And I have to agree with Mr. Bornstein. I think if there was some movement towards some type of ancillary framework or some guidance, that would, I think, help the municipalities deal with this issue in an easier way. But what I'm hearing is that doesn't appear to be a possibility. I mean, I just want to be very honest and straight up about it. It does not appear that the IG's office is in a position to be willing to look at that at this juncture.
Well, I'm not willing to accept the definitions as they have written, which is what we're on right now. And again, with respect to procedures, we have them in place. They're based on accreditation standards because we'll be seeking accreditation, and certainly each city, and we can sit down and go through what those are. But I can't sit here and define for you when a complaint comes in whether or not it's something we're going to. You have to use your judgment and the experience of the IG office to know where it's going to. And again, regardless of who reports, the issue is what's being reported, and do we need to get in there to determine whether it's true or not? And it is just as important to clear someone as it is to say someone did something wrong.
Okay. Well, perhaps the path there is to look at those regs and determine.
Mr.
Yes,
Chair?
yes.
Could we sidestep this issue and go on to the next one and maybe bring another round of potential definitions back at the next meeting?
That's up to the committee. I just, there's a fundamental
Well, then it comes
difference
down-
of opinion
comes down
here
to
as
vote.
to, it's a yes or no issue. The first issue is, are there going to be definitions in the ordinance? And if yes, what are they going to be? If no, then we don't go to the second step. So I'm afraid we need to deal with the issue of whether the definition
Well, then
should be included in the
I'll
ordinance.
make a motion that we have a definition section, and that we'll work on some definitions. But I guess let's resolve that issue. I'm going to make that motion that we have some definitions.
I second.
Okay. Motion second. All those in favor?
Aye.
Aye.
I'll say aye also. So we'll have to come back to that then. In other words, it passed.
Pardon?
4-3.
What was who voted for?
The Mr. Bornstein, Ms. Ashton, Mr. Bresner, and Ms. Downey.
Okay. All right. I didn't hear that.
Okay.
And we'll bring that back in the next meeting, Mr.
Could
Chair?
we, if we're going to work on definitions, I mean, are there some guidelines? Because probably Trila and I are going to draft something. I mean, I just want some guidelines because.
Well, I think you should review them in light of the state attorney's comments, taking those into account, attempting to address those. And just for information, number 3, the misconduct requiring knowledge, I perceive that as being problematic. And I would not, I think that's a problem to establish knowledge of misconduct. I mean, oftentimes you may not have a rule, procedure. It's common sense that in the case of an employee or even a contractor that there's certain things you don't do. You don't have to have a rule or policy that, an individual should know that. You shouldn't have to have a rule to tell them that.
In the
have
discussion about these being in the criminal justice standards, which is what DOD, if there could be some attention to that issue as well.
Okay.
Thank you.
All right. The next 27 through 50 in the ordinance, and that would be the section of the authority and powers, functions, authority, and powers of the IG. We have, there are edits in the Trill White version of lines 89 to 98. In some cases, there was language added to the extent provided by law. There also are 2 subsections that were proposed, and this would, if you look at lines 100 to 108, per the February 17th draft from Ms. White, those were some changes, substantive changes possibly, in this section. So we need to talk about whether or not these are to be considered to be added into the ordinance.
Mr. Chair?
Yes.
I can speak of 36 through 44. That is some clarification about the standards and taking sworn statements, and I've added both the auditing standards and the investigative standards in that.
Okay.
And
I think we
can make a motion to move it if we want.
Well, there were some edits to
right
that.
here.
Lines
sorry.
36 through 44.
I think that there were some minor language proposals from Ms. White in her report, even within that language that had been proposed. Excuse me. This does reflect moving towards accredited standards and utilizing those as a guidepost. But I think that in my review of the material from Ms. White, that there were some language within those, if we're looking specifically at lines 36 through 44.
Can I not make a motion to at least accept this language if we want, and then if not?
Yes, you may. I'm sorry. Is there a motion?
The language we're talking about is in lines 36 through 44 of the draft dated 2/9/11.
That's correct. So there was a motion made.
I'll second that.
Okay. Okay. Now on the question. Thank you.
Can we have discussion?
Yes.
Cheryl? Yes. I continue to remain to have a concern with the sworn statements. And I guess I would just like to be clear as to how those benefit the IG and the performance of its duties.
Well, first of all, it's an accreditation standard. We have to do it. If we don't do it, we will not get accredited. It is a common practice in the Inspector General's operations. It is to put somebody under oath that they attest to what they're telling us is true and accurate. They're all notaries, and it is a standard practice and a requirement under accreditation.
But, okay, I understand that. I don't, does the ordinance as it currently exists require that the office be accredited?
That has pretty much been a very profound statement made from the selection process on that this office get accredited. It is not specifically written in the ordinance, but it was pretty well, just, out there with the selection committee and from the Commission of Ethics, and when we went through this process, that one of the things that stood was the fact that this office would get accredited.
Okay, but assumedly, statements that you are getting, at least from officials and employees, contractors might be different, because that'll be in a different context. But hopefully those will be true statements, and if they are not true statements, there could be a consequence, at least for employees, of the failure to cooperate in terms of disciplinary action or termination. So I'm back then to what exactly, how do you benefit the fact that I took an oath and made those statements as opposed to I make a statement?
Well,
I mean, if I've made misrepresentations or I lied, there's still potential consequences to me as an individual.
When you're coming into an interview and you just speak versus coming into an interview and put under oath, like any officer, you would think that you're attesting that you would tell the truth. When you just come in for an interview, you're not attesting to anything. But when you're put under oath, you are attesting to telling the truth.
But, and now we're going to get into the practice, and, you'll have to address this because I don't have actual knowledge of, because the investigator hasn't asked me any questions yet. So my concern, as I articulated before, was if I am asked to come immediately and make a statement and to answer questions, I'm at the age now where my recollection is not as good as it used to be in my 30s. And, I may think something that may seem rational to me, but I may be mistaken. And when I go back and look at my notes, if I've taken them, which I often do, I may have said things in error. So, and if the goal is to get at the truth and accuracy of the statements, then in those circumstances where, in my case, if you called me and immediately started to question me, hopefully what I'm saying is accurate, but I would never guarantee it because unless I, was very certain of my recollection.
Well, I would hope you would call us and say you looked at your notes and you had a few things that you weren't quite accurate and come back.
But if you've taken a sworn statement.
It's to the best of your knowledge when you take that sworn statement.
Well, I just have a concern giving a statement under oath when I could be placed in a situation where I may not be certain of the accuracy of my statements if I'm just answering questions. Now, if you call me in and say, I want to take a sworn statement on this day, then hopefully I have had an opportunity to know what I'm talking about, look at my notes, make sure my recollection is accurate, and try to, represent that those statements are correct.
Well, traditionally, we wouldn't say come in right now. I mean, it depends on the circumstances of what's going on, but traditionally, if you say to the investigator, can I have a day or two, does this day work, they'll go, absolutely. I mean, it's only on, issues if we've got something that's triggering a criminal case or something where we need to get at something very quickly to get over the state attorney, but for the most part, if you need a day to, do your recollection, there wouldn't be truly, on most cases, there'd be no reason that you need to come in right now. So we want you to remember that's important. The flip side is you have to be careful that you don't want someone to destroy evidence. So there's a delicate balance there as to how quickly you need a witness in. But in your situation, if we're just asking you for procedurally what's going on, that's not something that's emergent, that something could disappear. So there's not that urgent, you have to come right now.
But I guess I'm still unclear as the actual benefit, because in the situation of myself or an employee, the statements that we make should be truthful. I mean, it's, I would say it's not in the course and scope of my employment to lie.
Well,
But,
I will tell you, some of the county employees that have said, I don't know how you got this, this information. We could never get it. So again, when it's a requirement, it's a practice that we've always done, and we do. Some people tend to tell the truth when they're put under oath, as opposed to just coming in cold and saying, come tell me everything you want. And I can't sit here and debate. I mean, the bottom line is we take that as a standard practice in the IG community. It is a requirement for accreditation. If we don't do it, we will not be able to seek this office for accreditation, which would be, in my personal opinion, I think in the selection committee's opinion, a big mistake for this community.
And I understand that in the context of a federal inspector, which is conducting a criminal investigation, they would need that testimony to be sworn. But in our context, I just don't understand the benefit of it. I think there are a lot of risks associated with employees who make a sworn statement not realizing that they need to qualify, or anyone. I mean, I'm talking about employees because that's my personal context. But anyone who would make a statement not realizing that they're being asked to swear to it, and what the ramifications of that could be.
I mean, they get put under oath when they come in, they talk, and then many provide sworn statements. Some do, some don't. So they're providing that sworn statement in their own handwriting, and it's being notarized. So, if they come back and say, I made a mistake, then they do an addendum to that statement. We've had, I've had one person come in and do that. I mean, the idea here is to get at the truth. Mm-hmm. We need the facts. And so if there's, just like when we give the report to the subjects before we release it, we want to make sure that nothing was missed. And if they have something that's, turns the case around, we'll look at it. Because at the end of the day, the ultimate goal is to make sure that the facts are accurate as best as everybody knows it.
And I have no disagreement with that. I just have concerns regarding the legal import, if you will, of a sworn statement. When it's not transcribed and you don't have any opportunity to see it and correct it.
Okay, thank you. If you were to look at the lines 36 through 44 of the draft, the Cheryl Steckler's draft of February 9th, and then if you were able to take out, please, the Trio White ordinance and look on lines 89 through, basically 88 through 98, you'll see a side-by-side comparison of the language where, and I'm not getting into subparagraphs A and B yet. I just want to get into the paragraph above there to see the language that has been proposed by Ms. White, and I'd like Jennifer to possibly go through those once we're to that point of finding the document. So it's like, where's Waldo?
Yeah, I'm lost.
Okay.
Are you, Mr. Chairman, are you talking about the two phrases, a couple of phrases,
Yes.
to the extent permitted by law,
Right.
which would be inserted if we were to agree to it, which would be inserted after the phrase, after the word information on line 36 of the Inspector General's draft?
That's correct.
And other applicable laws, which would be inserted after the word statutes on line 38 of the Inspector General's draft.
We don't have the right draft. I don't know where we're at.
This is in the February 17th version.
We have too many
of the real
drafts.
one, which was in your packet.
This one. Right. This is the version. Okay. And you're on line. I think this is.
You said line 36, I think.
No, you're looking on the 8. It's on the 80s.
Yeah, you're in your draft, it's line 36 through, basically 35 through 44. In Ms. White's version of February 17th, that would be lines 89 through 98.
Okay.
I know it's confusing. Are we there?
Mm-hmm.
Okay, good. Okay. Jennifer, thank you.
I'll talk about the two changes that Trila and I made together because they deal with the same subject matter. On line 90 in Trila's version, we've added in the phrase, to the extent permitted by law, with respect to an employee or manager or whoever's requirement to cooperate with the Inspector General to provide statements, documents, records, and other information. The next sentence, we've also added that the Inspector General may obtain sworn statements in accordance with the Florida statutes and other applicable laws. the reason that these are necessary is because there may be constitutional rights coming into play that need to be acknowledged and observed, and there might be a situation where you might not be able to get a statement. But more importantly, or not more importantly, but in addition to constitutional rights, there are situations your Inspector General is going to be able to look at the private sector that is doing business with the county and cities. And the private sector has very specific privileges in the Florida statutes and in federal law that might come into play when the Inspector General is trying to get documents, get statements from them. There's attorney-client privilege issues that might come into play, and there's also trade secret privilege issues that might come into play when you are dealing with the Inspector General, or when you're dealing with the private sector. So that's why Shrila and I would recommend that we put that type of language in addition to what Ms. Steckler has already recommended.
Okay, thank you. Mr. Baker?
Well, I guess my question would be what's really added by those? I understand what Ms. Ashton is saying, but to the extent they're permitted by law is said without being said, is if it's not permitted by law, then it's not permitted by law, whether it's said that it's not permitted by law or not. And other applicable laws, that's a phrase that is dangerous because I'm not sure applicable is a word that could mean any group of laws that someone could argue the applicability of. Now, if we want to be more specific as to the laws that it is in accordance with, for example, the Florida statutes and laws of the United States, I'd be okay with that one. But other applicable laws is just, to me, way too broad. I'm not sure what it means. And I'm not sure that to the extent permitted by law is necessary. If it is permitted by law, it is. If it isn't permitted by law, it isn't. To the extent permitted by law are, to me, just excess words.
Mr. Chair?
Yes.
We actually talked about adding this phrase. It was in a little different placement at the time, the meeting before last. And we had a discussion at that time about confidentiality of certain records. We talked about straight secret, HIPAA, federal laws dealing with drug and alcohol regulations. So although I understand your point, David, and I think it's well made in general, my concern is that there may be individuals who don't realize that the Inspector General may not have a right to certain records that are requested by her office. Now, you know, Cheryl has told us she's well aware of Garrity rights, firefighter, police officer, Bill of Rights, you know, HIPAA, et cetera. But there may be a lower level staff person in her office who investigates and makes a request. There may be an employee at a municipality or even at the county that misunderstands a statement of an investigator as a request for records, which perhaps they weren't actually requesting because, you know, they may say, we may need these records, and that person construes that remark as produce it, and the investigator is thinking, I need to go back and check with the Inspector General about my ability to obtain that record. So I think it's there appropriately as sort of a check that, you know, there needs to be some follow-up inquiry as to the ability to produce certain records. I mean, the local governments deal with public records laws all the time, and issues come up frequently as to whether records may or may not be produced. And just a broad statement of may obtain, I think there needs to be something there that puts in the mind of the individual, I need to make a further inquiry.
Yes.
Just to follow up with Ms. Rainey and then to maybe address some of Mr. Baker's concerns, to the extent permitted by law is, I believe that's commonly used in the statutes. I've seen that before. But also, as Ms. Rainey said, it is to give notice to people that they might have rights with respect to the Inspector General that they didn't know that they had. And again, it is to give notice. Mr. Baker, I am fine if you want to redefine other applicable laws to include maybe the Florida Constitution and federal Constitution, federal statutes. I mean, that's fine. If you would like to have that more clear as to what laws we're referring to, I don't have a problem with that, but I do think that to the extent permitted by law should remain.
Yes.
Just a quick. I agree with Mr. Baker on this one. I just think to the extent permitted by law is unnecessary, especially if it's referring to the Constitution or anything else. This does not trump the Constitution. It doesn't trump state law. And so I just think it's not necessary in this paragraph.
What about the discussion under and other applicable laws to define that further? Or you feel that's not necessary either?
I don't think. I think the original language is fine in this section.
Okay. And that was the original motion that's on the floor and it was seconded.
To accept Ms. Steckler's language as is?
So unless there's a motion to amend that, we'll need to move on the motion that is on the floor.
Mr. Chair, I would like to make an amended motion to accept Ms. White's changes to include the language to the extent permitted by law and other applicable laws.
Okay. Is there a second to that?
I'll make a second on that for just a comment. I understand what Mr. Ehrenberg was saying and Mr. Baker, it's basically understood that this function comes under and is subject to those laws. But I think as a practical matter, as much information as we can give the employees who will be looking at or centering up these records. We have this problem a lot when dealing with HIPAA and other redacted things that we can't give out. As much guidance as we can give them in the execution of this is important. So that's why I would support it.
All right, so procedurally, we need to deal with the amended motion first. All those in favor of the motion as amended, please signify by saying aye.
Aye.
Opposed?
No. Aye.
Fails 4-3, or passes, fails 4-3, so we're on the original motion. So the original motion is to take the language as originally proposed. Now I'll get into subsection A and B next. So all those in favor on the original language?
Aye.
Aye. Opposed?
Nay. I haven't voted no yet.
All right, okay. All right, now, yes, the affirmative vote, the affirmative was Ms. Steckler, Mr. Ehrenberg, Mr. Bressner, Mr. Baker were voted in favor of that motion. Those opposed were Mr. Bornstein, Ms. Ashton, and Ms. Rainey. Okay. The other item that's in this language is the proposal to add a subsection A and B in the ordinance. And if you look at Ms. White's draft, beginning at line 100, there are two subsections there. So I'd like to have some discussion on that. First of all, it'd be appropriate if there is a motion to include this language in the ordinance. We'll need to hear that, and then we can discuss the matter.
I'll make a motion to include. You want to do A and B at the same time, or just A?
Yeah, that'd be fine.
A and B.
Okay. Is there a second?
Second.
Okay. Okay. On the discussion now pertaining to these items, I'll ask Ms. Ashton to discuss the purpose of the language and the rationale for including it proposing to include it in the ordinance.
Again, Trila and I talked about this language at length. There had been some discussion at prior meetings that there was a concern that employees might not understand that they have, or managers or whoever might not understand that they have Fifth Amendment protections. And I understand Ms. Steckler's comment that she is only an administrative body, but we still can't allow people to self-incriminate themselves. So again, these sections are put in for notice purposes to people, letting them know that they do have these rights. So sub A deals with Fifth Amendment, sub B deals with the right to representation. If you want to bring in your own attorney, you should be allowed to do that. Employees and officials also in bargaining units have certain rights with respect to union reps being present during these meetings and investigations. We did throw a sentence in here to say that the right to have an attorney and the right to have a union rep present can't cause unreasonable delays or unwarranted delays for the IG, because I could see a situation where somebody could say, my attorney's on a 3-week cruise in Greece and they're not going to be back and I can't come, and then that would definitely hinder her investigation. So that is why that language was put in there. But again, these paragraphs were added to give notice of rights.
Okay. Thank you. Comments?
You want to go?
When do we leave on the 3-week cruise?
I could use one right now.
See my comments above under to the extent permitted by law. These are legal rights that the If they have them, they have them. I don't really see any reason. I appreciate the fact that someone may want to give someone notice under this. Employees aren't going to read this document. Employees are going to be educated by their supervisor and by the attorneys for the jurisdiction in which they work. I don't think we need to restate the obvious in this document.
Mr. Bornstein.
And I just, on the other side of that argument, say as much clarity and information as we can give the people in the process, the better.
Question.
Yes.
Thank you. We're voting on both A and B together, or just A?
That was the motion.
Okay. The question I have is there anything in B that we're adding, or is that just a clarification? Is that
They're adding both A and B.
Both A and B are new language.
No, I'm sorry.
Okay,
I meant that is there anything substantive that is being added with B to someone's rights that doesn't exist without B being there?
Without A?
Without B. I'm concerned about, like, A I think is totally extraneous. But B, I'm sorry, because the Fifth Amendment obviously applies. But is there something in B that it says that people have the right to their own representation if they so request? It talks about collective bargaining. Is there anything in there that would not exist if B were not set out there? I'm wondering, are we giving an additional right? Or is this just clarifying something?
Well, I don't know. I think it depends on the investigative process and basically the rules that the IG provides as to whether or not there is representation offer is made as part of due course, as part of the investigative process. I'd have to ask Ms. Deckler as to whether or not, as part of your, if something has entered the realm of an investigation, what level of representation is afforded to the individuals being interviewed. Does that range based on if they have collective bargaining agreements, and if they don't have collective bargaining agreements, they do not have an ability to have representation?
It depends all on what they are. If they've got unions, they have a right to representation. We have notices for all that. If they have the Bill of Rights, they have certain. It just depends on the employee that you're dealing with.
Okay.
But yes, there's all afforded rights are there, regardless. You can. All we're doing is adding more language, but at the end of the day, whatever rights are allowed by the federal government, we follow those constitutional rights.
Well, but what this does add, this adds the default language that persons have the right to their own representation if they so request when questioned. So you could have an employee who is not covered under a bargaining unit that potentially then under this language would be afforded the right to representation.
Well, they can bring an attorney, and there's nothing to say that they can't.
Okay. And anybody can bring that as part of the investigative process.
Mr. Chairman, I don't want to get into too much discussion of this because we could go on with this point forever, but I'm not sure that implies that the employee has the right to an attorney or representation. At whose expense would that be provided?
No,
it says their own.
But it says representation. That means they can bring their cousin in. What kind of representation are we talking about?
Legal representation.
Okay.
That was what was intended by it.
Well, I think Ms. Steckler said something was very important. She said that during the investigative process, if I understood what she was saying, is that in any event, somebody being interviewed or investigated has a right to legal representation during the process.
Do you tell them that when you set up an investigation?
We just had someone come in the other day. There was a vendor who brought his attorney.
But do they know that when they talk to you? When you call them and say, I need to meet with you for an investigation, do they know they have the right to an attorney? Or they can bring an attorney with them?
I can't tell you whether somebody knows or not. If they ask us, we say they can.
That's why notice is important.
You don't read them the rights.
Well, the rights are different.
Yeah, anyone. Again, you got federal and state constitution. You got your constitution. It's again. I have to say, we're just adding more language that people's protection and afforded rights are given.
Actually, I'm kind of inclined to agree with Ms. Steckler on this because, you have the right not to incriminate yourself in a fifth. We had a long discussion about this last 2 or 3 weeks ago, whenever it was. And she made it very clear that she understands these state, federal rights. And also we had that discussion about 38 municipalities, how many collective bargaining agreements would be applicable. and just, the knowledge that she's going to have to ensure she complies with all the requirements. So since she has acknowledged that a person does have a right of representation, I can support not adding these to the ordinance.
Are we complete discussion on this? Can we get this to a vote?
Yeah, let's do it.
Okay.
Now, what's the?
The motion is to include subparagraph A and B in the ordinance as presented.
To include it.
To include it, yes, so. Okay, all those in favor of including paragraphs A and B in the ordinance signify by saying aye.
Aye.
All those opposed?
No. Nay.
No. So basically it's a 5-2 vote with everybody from Mr. Baker voting no.
Jamie's moving further and further.
Okay.
We took away from
Coming up on a break here in a few minutes.
Hallelujah.
Would you like to do that now, or do you want to, actually, if we deal with subsection 2, inasmuch as we've already addressed on a 4-3 vote, the language is except as limited in this, I don't know, that was provided by law. So there is language that's added to the extent permitted by law in Ms. White's draft. I am looking at subsection 2. Whether or not we want to include that or not, since that was said no the last time.
Let's move on.
Okay, all right, thank you. How about the language except as otherwise limited in this article?
Yeah, let me give a little explanation on that.
And again, that would be on line 117 of Ms. White's draft.
Trying to remember. Sorry, I'm trying to find my section. Okay. On line 117 in Ms. White's version of the ordinance, we added in, except as otherwise limited in this article, the Inspector General's jurisdiction includes but shall not be limited to all projects, programs, contracts, or transactions that are funded in whole or part by the county or any municipality. We thought that the language except as otherwise limited in this article was needed because there are certain other provisions in the ordinance that say she cannot interfere. For example, the collective bargaining negotiations. So that's why that language was put in there.
Okay.
Just to make it consistent with the other section.
Also in this section, Mr. Chair, there was a letter we received from Royal Palm about a concern about some of the public records issues. I think specifically the part that says that the Inspector General will have unrestricted access to records of the board. And the concern was, again, about the HIPAA or anything exempted from disclosure from Public Records Act. And I don't know if that's, I just wanted to bring that up. That was a concern that was raised.
Oh,
All right, let's hold that issue for, let's talk about except as otherwise limited in this article.
I'm not sure I understand the reason for it, but.
Again, it's a reference, as I understand it, it's to reference later on in the language, we talk about collective bargaining and, certain exemptions there, or limitations. And so I think what's being proposed here is to further elaborate on that there's language coming up that would have a limitation on the IG's role.
And later in this.
No, later in this subsection, in paragraph 2.
Well, it's hard.
Should we?
Yeah, let's address the other. How do you address this without?
Okay.
I mean, if you're limiting the role, I think I'd have a problem with the exception clause.
Okay.
Where in the rest? I'm sorry, Mr. Chair.
Well,
where's the language in the rest of the section that refers to?
Oh, let me find it.
It's on line 2728.
Right.
127.
127. In the teal color
127.
I don't have teal.
That would be if you're looking at what number was it?
120 on my version. It's 127, 128. The sentence is the IG shall not interfere with collective bargaining and negotiations.
Okay.
Again, we had quite a bit of discussion about that.
Right.
We did.
Actually, orange.
And we actually adopted that language.
Peach on.
Yeah, I think we're okay there, but I think the question is whether we want to add the language except as otherwise limited in this article.
Excuse me. Go ahead, man. I would entertain except as provided in the last sentence of this section, or the last sentence of this subsection 2, the Inspector General's jurisdiction shall not be limited. Basically, if we're going to accept something, I'd like it to be specific.
I have no problem with that if you want to say except as otherwise limited in this subsection.
Is it otherwise limited in the subsection, Jennifer, other than in that last sentence?
I don't believe so.
No, I don't think so either.
The only section that
All right.
would have a limitation.
And then my preference would be except as otherwise limited in the last sentence of this subsection. I think this is a subsection. And I'll make a motion to that effect.
Okay.
Second.
All right.
You actually want to say in the last sentence of this subsection?
Well, I'd rather say, we could say except as otherwise limited in the case of collective bargaining negotiations described below.
Why can't you just move that whole sentence up, except as from above, and then say that the Inspector General will disclose a little better?
I mean, why can't we just say subsection? Because there's only one limitation in the subsection. It's
That's right.
Pretty
Okay.
clear.
Yeah.
Fine.
Okay.
Me.
Would the maker of the motion agree to that language?
I will.
Okay.
Can we rephrase? Because you lost me.
I think the motion was to state in that exception, except as otherwise limited in this subsection, rather than article, and that would, and maybe we could go so far as to say except it is limited in this subsection 2.
Right.
Okay. All those, is that acceptable?
Yes.
Yes.
Okay. All those in favor?
Aye.
Opposed? No. Break time.
When do we leave
7
on the
minutes?
cruise?
I thought the lawyers only go on cruises.
Ms. Rainey and Ms. Deckler. Let's, when we're eligibly back on, I don't know if I'm live yet or not. Are we on again? Okay, thank you. It is 3:35 p.m. I would propose that we go till 5 or 5:15 p.m. today. Second, if that's acceptable to everybody.
Yes, sir.
Okay, yes.
We will do it.
You'll do it, all right? Good. Well, we have unanimous vote on that. The other issue is that we will not, I do not believe, get to the financial calculations and discussion today. So any of the souls that are related to that part of the project are released from duty if they are authorized to leave.
They've already left.
Yeah, I know. Some people have left. And frankly, I know some of the municipalities are still absorbing whether the electric utility numbers are in or out and some of the nuances of that. So I think it'd probably be a good idea. And I know the managers are meeting on Friday, and I know that there'll probably be some discussion at the managers meeting this Friday about the financing. And Ms. Deckler is our speaker at the Palm Beach City Management Association, and Boynton Beach is hosting that at our Intercoastal Clubhouse. So,
Do I need to wear a vest?
No, we
No.
we will make sure you're protected.
To the extent permitted by law.
All right. Okay. Touche. That was great. Okay. Before we move into the next subsection of the ordinance, Ms. Rainey, you had a question concerning the language that we just left.
It was, it's in line it's in line 122 of Trila's 217 version, and where did we find it? in line 55 of Ms. Steckler's edited 2.9 version.
All right, the language reads, "The Inspector General may contract with outside entities deemed necessary to perform the functions of that office. The Inspector General may conduct investigations and audits, issue reports, and make recommendations concerning collective bargaining agreements. The IG shall conduct investigations in accordance with applicable laws, rules, regulations, and not interfere with collective bargaining." So what's the...
It's just the first sentence of that section. We actually discussed that a couple sessions ago also, and my point was the Inspector General's authority to contract is subject to the approval of the Board of County Commissioners. She doesn't have independent authority under Chapter 125 to enter into contracts. And I thought we had actually discussed putting some language, but we couldn't find.
Yeah.
Okay.
This was newly introduced language, so we need to put it here too.
We need to put it here also.
Yeah.
All right.
And then I just had one general question, and it's kind of for Cheryl as to what your process is. Do you comply, in terms of procurements, when you need things, are you utilizing the county's procurement process?
Yes.
Okay.
Okay. So, Mr. Berger, you're going to provide a subsequent revision to that language in, which would be on line 54 of the February 9th draft that would cross-reference the Board of County Commissioners?
It's going to mirror 423(10) that talks about agreements with outside agencies. It's subject to final approval by the board, and it won't be unreasonably withheld.
Okay. Is that acceptable? Okay, thank you. All right.
Mr. Chair, could I have one clarification before we move on? I believe that I'm looking at Ms. White's and Ms. Ashton's draft, and the copy I have of that is 111. I think that's correct.
Right.
It starts out to the extent permitted by law. I believe that we agreed that to the extent provided by law would not be included. Correct. Is that correct?
Correct. That's correct.
Yeah. Okay. Thank you.
And we also agreed before we went on break that we were going to reposition or reword the other amendment that said except as otherwise limited in this article, there would be a specific cross-reference to being a part of a subsection.
I think we said except as otherwise limited in this subsection 2.
Right.
Okay.
And just for clarifications, going back to the 2.9 draft, would that go on line 60 then?
Well, it's somewhere between 57 and 58, somewhere in there. I mean, if it's the last sentence, then yeah, it would be on line 58.
Well, no,
Yeah.
no, I don't think so.
Okay.
I think we're talking about the language we're talking about is except as otherwise limited in this, and I think that goes before the phrase the Inspector General's jurisdiction shall not be limited to. The Inspector General's jurisdiction includes but shall not be limited to, which is line 55. No, excuse me, it's line 52.
Okay, I was just trying to get the placement so we knew where it was going.
Okay. We're moving at light speed now.
And you let the fiscal guys go.
Mr. Chair, we're still in section 2.
I was hoping not.
Well, we had one issue I raised that we got in a letter from Royal Palm Beach regarding unrestricted access to records, and was asking the question if specifically does that mean the Inspector General can review and make copies of documents that are prohibited from disclosure by Fed or state regs? And, of course, HIPAA always comes up, or Public Records Act.
We have unrestricted access, but we also redact to ensure that most of the time we don't need any HIPAA information, but if we happen to come across it, like any organization we work in, and we always redact, we have to follow 119 just like everybody else. So it just depends on where we're at. If we don't need to take the records and we do them on site, but if we have to make copies, we have the access, but we have to follow the law to make sure that it doesn't go beyond that.
So in response to this, clearly it's not a violation of HIPAA or the Public Records Act or any other act that if you have access to those, you're another governmental entity, and therefore we're not violating, a city wouldn't be violating any rules. If you make copies, then the onus is on you at that point, no longer on the city. Is that?
Yeah. If we release an error.
I'm getting eyebrows from the county attorney over here.
Well,
I'll put my glasses on to see what that.
There may be some public records law consistent with what Cheryl's talking about, but there may be other federal statutes. HIPAA is one. I think drug and alcohol test ones for certain types of employees that I would be very concerned about our ability to release them. Even if she is arguably an extension of us as an agency, there are records that only certain people in the agency have a right to by federal law, and I don't believe she would be entitled to them as perhaps I wouldn't be, or you, or whatever.
Correct.
And that's my reason for my concern, and I wanted that language in there. So, but she's going to have the duty of making sure before she gets something that she's lawfully entitled to it.
And with HIPAA and things like that, there's never really a need that our office, when we're looking at government programs, and there's really no need. But we would not, certain people are allowed to have HIPAA information, certain are not. We would not be retrieving anything that we are not lawfully.
It's really strict. You have to keep it under lock and key.
When you have overarching language that says full and unrestricted, it's the worry.
I don't know why we need it.
When you have full and unrestricted, that's the worry that was expressed here. So.
Right. And that was my recommendation, that sort of a check, I need to make an inquiry. That's why I wanted that, to the extent permitted by law language, so someone would realize. I don't want to go
the Baker phrase.
Yeah, I already explained the rationale, but.
Just to clarify, Ms. Steckler, you said that you are subject to the same public records laws. Like if you were to come into Lantana and they had public records that were exempted from disclosure to the public, are you?
No, what I'm saying is I have to abide by the public records law. So when I have your records.
So I don't give you the records.
No, you give us the records. I can't then go release if it's not. If there are records that are confidential, we have to make sure that we coordinate with you all and redact what is not releasable information. I have to follow 119 like anybody else when it comes to releasing of records.
So what she's saying is if she obtains a record that's confidential, the obligations of confidentiality extend to her.
Extend to me.
Right.
So you're just an extension of our cities. So we're not going to be losing, I think Mr. Liggins brought it up, we're not going to be losing any exemptions if we turn over our documents to you.
No.
Okay.
Okay.
When we have, like right now, I have a public records request, I'm working with the county to make sure any documents they have, we make very sure before we release any documents.
But Jennifer, there are certain records that she may not be entitled to receive, notwithstanding the confidentiality. Sure. That's why you need to check with your attorney to make sure.
Okay. If she asks for a record that she's not entitled to, and my attorney says don't give it to her, but then I'm going to
then we'll sit down and talk about it. And, with my general counsel and your general counsel will talk as to why or why not that record. And again, if you're talking HIPAA and drug analysis, those are not things that we would necessarily ever need, nor would I want. I don't want to be put in a position to have people's personnel, health issues, and it's totally irrelevant.
Okay. We've reached a very important milestone where Mr. Berger has suggested that an entire subsection can be stricken and relocated elsewhere. And I'm referring to lines 76 to 85, and this would be subsection 2-423-4, which was the subsection formerly known as the financial.
Mr. Bresner, before we move on to that, there were some other comments in Trila's draft that we have not discussed. There was one in subsection 1, and there was one left in subsection 2 towards the end.
Okay.
I just want to make sure that those are discussed before. And then there's one in subsection 3.
But we approved some of this. We've already approved.
I thought we approved the language such cooperation would remain as is. I didn't know we were talking about the first part of that paragraph. Did we vote on the entire paragraph?
I believe we did, yes.
Okay.
On 2?
Yes.
Well, I was talking about 1, but okay.
What on paragraph 1?
There was a small change at the beginning. Instead of saying other affected entities, just change it to subject municipality, because only the county and the municipalities are subject to this ordinance. If any other public entity comes in, that would be by pursuant to agreement.
But I guess the language also can contemplate that, and I don't know if it's,
Well, what does affected mean? That's,
well,
can we just say it? All right.
what about participating, participated entities by, and then do a cross-reference to the interlocal agreement if we have to do that, but I wouldn't limit it just to the municipalities because it can be broader scope. There may be subsequent participants in it, so I would have some concerns about
I wouldn't have a problem with saying participated entities pursuant to the applicability section, whatever
Right,
that
I
ends
think
up being.
Lenny?
Yeah. I'm trying to find where this is. I'm sorry, I don't know where we are.
It's on Sheila's.
I have two of, I have the 9th and the 17th.
It's on the 17th. It's line 86.
86 of what? Okay, oh, okay.
I don't even have a 17th.
Okay, sorry, wrong first section.
No, here's 17.
Okay, it's on 86 of Treeler's draft, and on
And you may want to talk about your rewrite of 2421 subsection C, and the reference to.
Well, that was already, that was approved.
That was approved.
Right. But
And what is this? Prepare reports and recommendations to?
you know, there can be a cross-reference back to what is now Section 2-421, 2 subsection C. In that language, I mean, if you need to tie it back.
That would be fine. Just want to make it clear what affected.
Sorry.
I'm just getting warmed up now. Starting to, that break helped
I
me.
shut down at this hour.
Oh, right. Break
I'm
kind
up
of gave me
early.
my second energy. I'm ready to roll now. Okay, so Lenny.
So what are we going to do?
All right, so under, if you look at subparagraph 1 under the line.
Right, 86.
Right.
86.
You would then add somewhere in there a cross-reference back to 2-421 2C. So it's clear that they are basically either the municipalities or their subsequent participants.
Okay.
it's the issue of an entity agreeing to be bound
Right,
pursuant to
and-
agreement rather than
Right.
just the jurisdiction of the ordinance.
So it covers not just the municipalities, it covers any subsequent.
To the board, other municipalities or other entities subject to the jurisdiction of this ordinance?
I liked what Mr. Bresner is.
I would tie it right back to the section.
Yeah, participating entities as defined by section 2-421 sub 2C, something like that.
Right.
Participating entities, all right.
Okay. Now are we to Mr. Berger's speech about eliminating an entire section, subsection?
No.
No?
Well, sub 3, there were a couple of changes to that about the subpoena power on Treeler's draft.
Okay.
Sub 3 starts at line, I think, 129 on my copy.
Forgive me, we have two of Trula's drafts, so we're
It's
talking
the
about 17.
17th.
Thank you.
Just take out the 9th. We're not talking about the reorganized.
Okay. Lead us through it, Jennifer.
Sure. On my copy, it's line 133. In the case of a refusal by an official employee or other person to obey a request by the Inspector General for documents or for an interview without good or legal cause. And the reason this is in there is we would hope that the Inspector General would coordinate. And there could be situations where there is a legal reason why they're not required to follow a subpoena, Fifth Amendment, attorney-client privilege, trade secret privilege, those types of items. And there could be good cause as well. Say, for example, you're scheduled to have an interview with the Inspector General and your husband dies, and you have to go deal with that and you forget. And you don't want to have to be called into court to have to deal with that. There just needs to be some kind of language in there to deal with these kind of situations. Because the ordinance as it's currently drafted, if you refuse to comply with the subpoena, she can take you to court.
So the language without good or legal cause would be inserted after the comma in the word interview on line 62 of Ms. Steckler's draft, just so we can see where that.
Correct. And then the second part of that same subsection, which on my copy is line 143. In the case of a refusal to obey a subpoena, again, without good or legal cause.
Mr. Baker.
Yes, Mr. Chairman, is that in the case of refusal to obey a request by the Inspector General? The Inspector General have the right to subpoena. So the only thing that's happening there, as I understand it, unless I'm misreading it, is that if they don't show up, you can subpoena them. Is that right?
Then it goes on to say if you don't obey the subpoena, you can go to court.
Well, understood, and that's the same consequence of not obeying a subpoena if I'm a rank-and-file citizen, not an employee, but if I'm just David Baker is subpoenaed and doesn't show up for the subpoena, can be compelled to come to court and show cause why I didn't respond to that subpoena. I don't understand why that should be any different for a person. That's the second chance the person's had. Once they didn't show up at the request of the Inspector General, and then again they didn't show up when they were subpoenaed to show up.
I just think that there could be situations that arise, whether legal or personal issues, that there might be an inability to comply with the subpoena by a certain time.
And there could be, for me too, if I receive a subpoena not to show up, in which case I either work myself out of the subpoena by calling and rescheduling my deposition or appearance, or hire a lawyer. And that's difficult if you're, maybe difficult if you're an employee. It's also difficult if you're me. So, I mean, I just don't see that the person should have a right to a heightened right to deal with requests to appear or subpoenas than an ordinary citizen would. Yes.
Cheryl, how does this work? You issue a subpoena. If an individual doesn't respond, then you have to go to court to get a motion to compel?
Well, right now, we hope that we don't ever have to issue a subpoena because all records are available. But if it came down to that, then yes, we would have to, if they refuse, we have to ask first, so that's level one. If you fail to comply, that's level two. Then you go out and issue a subpoena like any other to produce records or bring in testimony.
But if the individual doesn't comply, then you go to court to compel enforcement.
Correct. A judge would make that judgment.
A judge would make the decision. So in those cases where someone's spouse had died or some, horrendous fact situation.
Well, we wouldn't even get to a subpoena level. If somebody's spouse passed on, we just reschedule the interview at a convenient time. I mean, the goal of the Inspector General is not to issue subpoenas. I mean, we really want to stay away from that. Ultimately, it's there only if you need be.
We're making the same arguments that we were with the extent permitted by law. So if it's the committee's pleasure, we'll just move on because I think Mr. Baker was making the same arguments. Unless Mr. Boyce
I'm always a proponent in this process of being as clear and providing as much guidance as possible. So unless.
How do you define good or legal cause?
Well, she just did. She said if somebody's died, that's a good cause.
All right, so if somebody's died.
She just
put that in there.
Or the other thing, if she subpoenaed HIPAA records and then you said, no, you can't have those. But I don't know that she would be able to get them until she went to the court, and the court, I don't know how this works. That's why I'm asking. Lenny, do you know?
Well, this is an administrative subpoena under 162. So you have to, when you ask for it, you have to show cause for it. And then when the person says, well, hey, my husband died or something. But you do, I mean, at some point you might have to go to court to do that. But that all depends on how far, this office is willing to go to chase this person down. and immediately or not. So.
And if she
But that's
does go to
important.
court, couldn't the individual appear at the court and
Yeah,
say, I'm
and
sorry,
say,
my
"My
husband
husband
died,
died."
or I'm sorry,
You're
these
right.
are HIPAA protected, she's not entitled to
Correct,
them.
and then it's over. Yeah.
But why wouldn't you want the insurance and why would you want to make the widow come to court to explain it? I mean, you're putting, just put it in there. Come on, help the widow.
Good cause are words that we would argue about until Star Trek ended, and that will never happen. I mean, good cause is just mush words, and I'm not sure what legal cause is, except something like what Donna raised, which is HIPAA records, and I just don't see that we gain anything by it. Again, I guess.
Okay, I'm counting noses here. I think we're going to be okay on dropping the language. Yeah, so don't oversell. The last line, though, is to give testimony relevant to the matter in question. That would be on line 143. Any comments on that?
We made a similar change, I believe, in the Commission on Ethics.
Right.
The phrase touching on was present, and we just changed it to relevant to. So just to make the code consistent, that was
And
why
I
that was
agree,
proposed.
I think David actually suggested that term. And
Absolutely.
So counting the noses on that, we have, we can add that language. Okay.
Yes.
Are we to the point of the speech?
You really want the speech.
I want Mr. Berger's speech as to the fact that he's proposing the elimination of an entire subsection of the ordinance and relocating it to what will become Section 2-429. We're not going to talk about the substance of 2-429 because we've released the financial people. But so that's acceptable, everybody?
Just waiting for it or moving?
Do we have to listen to Lenny?
No, you really don't. If you were to say this is a good idea, then we don't need to hear a speech.
What's Ms. Steckler say?
The middle of the board on this or the committee on this one?
All right, so that's.
I think it's a great idea.
It's gone.
Great idea.
It's gone. Thank you. Well spec. Nice speech. Okay. Next one, if you look at lines 89 to 95, this would be on Ms. Steckler's draft again. There is some language here about the role and the responsibility of the city and county administrators regarding reporting requirements on violations that fall under the jurisdiction of the.
What one? On my draft?
Yeah, on your draft, 89 to 95. It says the county administrator, the municipal manager, or administrator or their designees shall notify the Inspector General of possible violations of any state, federal, municipal law or rule or regulation.
My numbers aren't matching.
Yeah, we're not matching up numbers. That's why I'm confused.
Oh.
That's not my number.
How about beginning on line 90? I'm sorry, 89.
This is from February 9th.
You're on the wrong.
I got February 9th working off.
Okay.
Do I have the wrong one?
No, that's one.
I'm working on
104.
104.
104? Okay, I'm sorry. Oh, got it. Line 104.
Well, I'm looking at 29, and I show 89, beginning on 89.
What were we looking at?
Wait,
You're kicking up a breeze over here.
yeah.
I'm baffled.
Line 104.
Well, you've got the comments, so maybe it.
Just look at the subparagraphs. That's how I do it instead of trying to count line numbers. So I can't find it.
Subparagraph 5, is that?
Yeah,
We're at subparagraph 5 of section 2-423. So let's get into the language here about the role of the administrator, municipal manager, about notifying of violations.
Mr. Barrett, am I ready?
Yes.
What this is, the county has established a procedure in place for certain elements that are to be reported to our office. When we're dealing with 38 municipalities, I would have to individually go to each municipality to try to get them to at least come up with some kind of reporting requirement to the Inspector General's office. Most of the requirements are like fraud, bribery, corruption, things like that. So I would like to try to address it in the ordinance rather than try to go to 38 municipalities and get a procedure passed per municipality and have some consistency across the board. How we get there, I'm open, but that's the concern I have, is trying to do this 38 different times.
Mr. Chair?
Yes.
To me, that's just allows the Inspector General to act as kind of the traffic cop for serious issues that may affect multiple jurisdictions in Palm Beach County. And I'd offer as an example of that, I mean, you may have a contractor in one city who gets in trouble with the city. And that same contractor may be doing business in 1 or 5 or 10 other governments in the city or in the county. And it would be important, in my view, to be proactive for all of the jurisdictions that are subject to the ordinance to be reporting back to a central repository for potential trouble. And that's what I see that is.
Okay. Any other comments on this?
I have a just concern that it's very broadly written and that it could encompass some small violation of a rule, which would be a personnel matter, and you would not care about, you wouldn't want to hear about necessarily. And so to the extent that David talks about serious violations, I don't have a concern with that. But the way it's written, it's also possible violations. And that's, to me, problematic. I don't like the word possible because that could lead to an obligation to report many things. And
how about suspected with that? I mean, because you can't prove the case until you know it's maybe suspected. I'm open to the language. It's just trying to get consistency across all 38 municipalities.
Yeah. I think the concept, I understand that. I have a little concern with the way it's vague, but I think we could probably tighten this up to get at what you're.
Right.
Yeah.
That'll be a practical function logistically.
That'll be a homework assignment for Mr. Berger.
Since we got it.
Since you had nothing to do in the prior section, so you might as well.
I think I want to strike this paragraph. Seemed to work well last time.
The other thing I think will help, too, though, will be as the process rolls out to have, again, administrative guidelines that can be shared with the municipalities so to give us an idea of really, not with exact specificity, but the type of things that you feel, you need to be looking at. I think that will help us.
I'd appreciate any input also from the committee on this, on where because I don't want to start affecting policy changes here. And I know you want to do something, but somewhere between possible and absolute is a really big.
Right.
Could I?
And any rule could be that employee didn't stop at a stop sign.
Yeah, and my thoughts on that subject. First of all, I do think possible is important because the sooner the IG knows about the possibility of misconduct, the better off we're all going to be. But I can understand Donna's problem that immaterial actions shouldn't be the cause for having to report. And I don't know whether the word material has any meaning in this context. It's meaningful to me in a commercial context, but I'm not sure it's meaningful in a governmental context. But my thought would be that some measure that would be indicative of materiality, Lenny. I think that's where I'm going with it, and I don't know whether the folks who have to deal with this in the municipalities have any other thoughts on that subject.
One of the things that might also be helpful is, given the open nature of this, maybe we can tighten it up, but it's never going to be as precise as everybody wants it. I think it might be wise in here to have some sentence that says failure to do it isn't some kind of gross violation unto itself. Not an invitation to overlook a violation, but if you don't want people wondering if failing to stop at a stop sign is something that ought to be reported.
Or just say, take something, a contract provision where a contractor doesn't comply with it. Well, and then the city or county, the contract manager says, you've done this wrong, you need to correct that. Or maybe they applied a liquidated damage penalty to it because he did it wrong. I mean, that's my concern. It's so broad, and I think we're all saying the serious material things are the things that need to go to her. I think the language has to be.
All right, it's a good addition, but it does need to be tightened up. So
Operators are standing by.
Okay, all right, that'd be great. Okay, thank you.
I just wanted to say, Ms. White had originally crossed this out, but I think her concern was more along the lines of it being overbroad. There could be a potential for duplicative actions, but I think you explained that today already. That if an attorney general investigation is already going on, then you'll let them finish their investigation. So I think you answered our concerns with that paragraph.
Okay, if I might, I could ask Mrs. McKenna to come to the microphone, because we're queued up on Section 2-423-6, and this deals with purchasing policy and making sure that the IG is not promulgating purchasing policy. So I guess that would be the best way to summarize your concerns.
I think that's it. And I don't think that's what was intended by the ordinance, but the use of the words establishment of, I think, suggests that she would engage in that conduct, or the office would engage in that conduct.
So the language, unfortunately, on my 154, understood. But basically it would read, do we eliminate the word, the establishment of bid specifications?
I think you leave bid specifications in and just take out establishment of.
I'm not sure which. I'm lost. I'm sorry.
It's
which
on
version?
page
on your draft.
113.
I think it's 98.
It's 113 on yours.
113.
Section
The,
6.
the line starts including but not limited to establishment of bid specifications, bid submittals, activities of the contractor, et cetera.
Strike the word to establishment.
Okay. Well, you've got line 113.
Is it same as yours? That's the same as yours. 113.
Okay.
Is that acceptable to the committee?
Yeah. It is.
Okay, yeah, I'm not going to create your specifications, so yeah.
I didn't
I'm
think,
sorry,
I
just
didn't
need to
think
read
that's
it.
what you wanted to do.
Thank you. Okay. Anything else on subsection 6? I didn't see anything else. I thought it was just based. Yes.
In my memo, I refer to 423, 6, and 9, and those are the notices. And I don't know if now that Mr. Berger is going to do some redrafting, that will take care of that. But we are just trying to get to what the consequence would be if inadvertently we didn't give a notice.
I need to go back because actually, and I'm sorry I did not get this to read it in ahead of time, but I do have a concern that if we can't, after the fact, look at how you did your bid specifications, and maybe this isn't worded correctly, I would want the ability to go back and do that.
And we agree with that 100%.
Striking that language may cause that.
It's just establishment of. In other words, we wouldn't have to come to you to establish our bid specification, but it would in no way limit your ability to come back afterwards and say, gosh, you guys could have done this a little bit differently, and you might have got a better pool of vendors or, a better product or something.
How about the process of creating? Where does it say that?
Procurement process including.
Oh, okay. Well, procurement process is actually working, but when you're creating bid specs, I think that's what she's meant by saying establishment.
Okay.
Yeah,
is how that occurred.
Typically, staff establishes a bid spec.
Right.
They have usually, depending upon how involved it is.
I apologize. So we're just striking establishment of. You're leaving bid specs in.
Right. Oh, absolutely.
Yeah, that stays in.
Absolutely. Right. Just the words establishment of, because I don't think that's what you probably want to do.
But you want to have the ability, though, to make a suggestion.
Or if in the establishment of it was corrupt, a process, that we can get in there to make sure, when someone writes a proposal, there could be, unfortunately, wrongdoing in that process.
And I'm fine with that. What we're concerned about is that this can be read to suggest that every municipality has to come to you and say, we need a bid spec for fill in the blank, and have you establish the bid specs. And I don't think that's what was intended.
I think, Inspector General, I think if you have the right to audit, investigate, monitor, inspect, and review the operations, activities, performance, and procurement processes, including bid specifications, you get there.
Okay.
Yeah, I think so, too.
Okay. I'm sorry.
That's all right.
And then the only other, as to 423.6 was just, and 9, what the consequence would be if there wasn't the notice.
Mr. Chairman, I'm assuming that Mr. Berger has that under advisement, and when he's redrafting, that'll be taken into consideration.
Yeah.
I think that was the committee's intent.
Yes.
It was ours, that it doesn't create any rights for.
Right.
Yeah.
So we'll.
No, for a protest, no.
We'll get those balanced on both those sections. Thank you. Appreciate the.
Yeah, we definitely don't want that.
Okay. Gosh, we're moving fast now.
See, we might get to the funding.
I don't have anything until section, well, that's subsection 9. We've already addressed that. Maybe not. Section 2-423-9.
I have a separate issue. I do have a separate issue, and we're just trying to get a handle on what selection committee meetings the Inspector General actually wants to attend and receive notice for. It would seem it would be where selections are going to occur, and not necessarily all of our advanced meetings about training and that type of thing. Because we could, in a city like the city of West Palm Beach, there could be several meetings of a selection committee before the actual selection meeting where vendors are going to be chosen.
Pretty much in the county, anything that right now, that if they deal with, if their procurement is on its way, then the notice goes out. Just like any other public notice, we just get CC'd on that email.
We don't, if I have a training session with 3 people that are going to be on a selection committee, I don't give public notice for that.
Explain to me what a training session is.
It would be, here's how our procurement code works. These are the sections that are going to apply. This is going to be the process. We're going to have a public meeting. You're going to sit in the room. You can't do this. You can't do that.
So that's the orientation
it's an
session.
Yeah,
it's an orientation
exactly. It's an
session
education meeting.
You really want to have the ability to be there if you choose to when the selection committee is meeting with prospective vendors.
From the beginning of that process to the end.
Right.
Yes.
Right. And I guess what I'm trying to offer is that in some cities, separate and apart from the vendors, there's education, there's information about subject matter, things like that have nothing to do with the vendors and have nothing to do with the selection. And we're just trying to get to the idea that may not be what you are concerned about, but the meeting where we give out the public notice and we say there's going to be a selection committee meeting to choose this particular service or this particular goods. It's a public meeting. We would give you notice.
Right.
You would come.
One suggestion would be that a notification form be prepared by the IG office that would check off that item, and so that the municipality would, when they are sending in the notification, they can indicate that this is an orientation session for staff, and it's while it's part of the procurement process, it's not to the point where they're talking about either proposals that have come in or talking with vendors. It's really preparatory to that. I mean, that's just I'm trying to think out of the box here to come up with something that.
Can I ask a question, Mr.
Sure.
Chair? What's at the heart of your intent in wanting to attend a selection committee? And maybe we can help determine where that point really is relevant.
Well, it was in the ordinance, so it gave us that authority. But basically what we're doing right now is we are sitting in on from beginning to end, depending on what the procurement is, for several reasons. One, to look at the process.
Okay.
Two, to make sure that at least the presentations are what they are, to make sure there's nothing going on during that process. it literally is to be a monitor and observer of that process. And then if there are issues that we see that are perhaps maybe in violation of or whatever, I mean, that can trigger an investigation later, or if we get complaints that there's, or that there's, something went wrong with that bid from the beginning, that the proposal was written, thwarted or, whatever. I mean, there's lots of process, but right now we watch the process and then we meet with staff afterwards and sometimes and go over some of the issues that we see, sometimes as a training mechanism. But the goal is to know about them and to follow this process as when we can. I mean, we obviously can't sit in every contract procurement, selection committee. There's no way. There's not enough of us. But as issues come about, or as we think that we need to be there to watch that process, we just go in and we watch it.
But it's mainly to when they're dealing with the people who are trying to get the business, when those meetings start.
Mm-hmm.
So the pre-meetings that may occur that Ms. McKenna's talking about, or some other types, really is not something.
On a normal basis, we would. I mean, collectively, we wouldn't do it unless there was something to trigger us to go.
You want to know about them.
But we want to know about them. I mean, we don't necessarily attend them, but we want to know about them.
But the way this is written right now is there's no obligation to notify you until a selection committee. So when the specs are being developed, when sometimes there's outreach to the vendors, right. They may be, you don't want to know
We
about that.
don't want to know about that. Now, some county departments have actually notified us just because it's a good preventative nature.
They want your input. So
Yeah.
really, you don't want to become involved until the point after the bid solicitation or the proposal solicitation has been issued. Do you all meet before that or after this?
It's possible.
It's possible.
Yeah, it's absolutely possible.
After the solicitation has been issued, and then when the selection committee is meeting as one step in the decision-making process, your meetings are not a part of the decision-making
Not
process
at all.
by that committee.
No.
So maybe we can do something with, that kind of distinction.
That was why I suggested the language that we give notice in writing when the selection of goods or services is to occur.
Is that too far down the process, though? Is that too far into the process, or can we back that up a bit?
The language as it's presently written says that the Inspector General shall be notified in writing prior to any meeting of a county or municipal selection committee where any matter relating to the procurement of goods and services is going to be discussed. Any matter can be the procurement code. Any matter can be when we're going to meet. There are so many things that come into any matter, and what I'm trying to get to help is what would be the important meeting for the Inspector General or someone from her office to attend.
Well, if you give us notice, we'll make that call. I mean, it's hard to tell you that one city, if they're making a procurement meeting to change their requirements. I mean, the grand jury report kind of touched on that about changing ordinance and codes. If we get wind of something that you're going to change a recommendation in your requirements before you put it out for bid, that would be a red flag. And so we'd want to know about that. Doesn't necessarily, it's a notice, it's an email. It doesn't necessarily mean we're going to go, but the more we know, it's really not a big, at least it hasn't in the county. They just email me a quick email. Here's what's on the activity this week or that day.
Counties and larger cities are more structured.
Yeah, and I don't have
the floor.
Maybe it would be helpful to know what we're referring to when we talk about a selection committee. At the City of West Palm Beach, when we have a procurement, we typically will have a subject matter expert. We may have a citizen. We may have, depending on what's involved, we'll have between 3 to 7 people typically. They're not involved typically in preparing the bid specifications or any of the pre-issuance process. The selection committee is not part of that typically.
But do they give recommendations to the selection committee of what should be in the proposal?
They are the selection committee. This language is requiring notice for the selection committee. We have staff who prepares our requests for proposals, our invitations to negotiate, our invitations to bid. Those are typically done by staff. Sometimes we hire professionals depending on what it is, but typically they're done by staff. We have to send out a notice every time staff gets together to talk about what we're going to put in an RFP would be virtually unworkable. You know, I mean, we just have dozens of them every week. So what we're trying to get to is what is it that you want to regulate and get notice of so that we can certainly do that. But there's a whole bunch of stuff that goes on before that. And this sentence is only about notifying you for meetings of the selection committee, which has is a term of art in procurement.
Ms. Rainey.
I just, in the county's procurement process, the selection committee is at the point where decisions start being made about the award of a contract. So in your case, your training sessions, that's informational. There's no decision-making taking place. So when until I really read your comment, Claudia, I didn't think it was an issue. But then it became what is meant by a selection committee. And so I think if we can in some way relate it to the decision-making process in the award of a contract, that narrows it enough that those pre-things that have occurred would not be subject to it. But she would certainly have the opportunity to look at all those records.
Absolutely.
Certainly have the opportunity to invite her to your pre-selection meetings if you so desired. But when I looked at this from the county's point of view, I thought it was when you start down the decision-making process. That's what a selection committee does.
Yeah.
They review the proposals, and they start down to, are we going to have a recommended award, and to whom? And those have to be in the sunshine.
Yeah, we have many non-sunshine, non-decision-making meetings.
Mr. Chairman.
Mr. Baker, yes.
I'm probably the person up here with the least knowledge of procurement, so I'll go ahead and make a fool of myself. Is the bullet, is the bright line when the bids come in, or does the issue start before the bids come in?
It could either way.
Okay. The selection committee probably would, excuse me, what Claudia is talking about, I think, the selection committee would have been designated, assembled, and trained before the bid came in.
Generally.
Pardon me?
Generally.
Generally.
Yeah.
And the process, if when the bid comes in isn't the bright line, going back from when the bid comes in, is there a bright line when the Inspector General needs to know for the efficiency of doing the job that there is a procurement underway?
The more we know, the better we can be preventative.
Sure, I understand. And I guess what I'm looking for, though, as Mike and Kurt and all city employees is a bright line where they know they're not going to get in trouble if they don't provide notice. And I think my kind of thinking through this, my thought is that on procurement number one, somebody from the Inspector General office may go and say, oh, my goodness, we need to go back before this, and may come back to the city and say, give us notice when you issue when you assemble it, when you appoint the committee, or give us notice when you decide to procure a front-end loader. I guess my point is, I think that the city's point is, and I can appreciate it, is that they want to make sure that they do give notice because they want the benefit of what the Inspector General's office can do, but they don't want to get in trouble for not having given notice. And I think the danger here is somehow threaten the viability of the procurement.
And I think we also, for the benefit of the municipalities, we don't want to add another layer of bureaucracy. Mm-hmm. Now somebody's got to, make sure that there's a form notice that goes out when we have a meeting. Mm-hmm. I think what we want to try and get to is what's the important notice, and perhaps rather than this language, because I don't think you're actually concerned about the selection committee. I think you're concerned about the procurement. So maybe what needs to happen is when a municipality is going to initiate a procurement, they give notice to the Inspector General. And not as to each thing that goes on in that procurement, but leave it to the Inspector General to contact the municipality and say, this procurement I'm interested in, and I'd like to have these notices, so that you always know what procurements are being initiated. We issue a report every week about the procurements that we initiate. That can come to you very easily and is not a higher level of bureaucracy because we're already doing it. But to try and notice the Inspector General of every single meeting that we have relating to procurements would be, we'd have to hire somebody to make sure that those notices went out. And I don't think that's what's intended either. So we want to invite the Inspector General into the entire process, but we want it to work smart. We want to, and we think we want the ordinance to work smart. And I think perhaps selection committee was where we got sidetracked, that it's really the procurement. She wants to know about the procurement.
And the selection committee is
Is a
potentially
part
product.
of it.
That's a product.
Exactly.
That's
It's
part of the
it.
process, but it's not the end.
Yeah.
The end of the process.
There are so many procurements. It's just, that's overwhelming. Lenny? Oh, sorry.
Would it make sense to say competitive selection process, so we're not talking about
Emergencies.
and
I don't know about that. I want to know about emergency.
Well, no, because I think emergency procurements are going to be an area the Inspector General is going to spend a lot of time with. A lot of time with. So I think you can't, I think it's more important, I think from the perspective of a city like ours, we initiate a lot of procurements, and we would be happy to provide that notice. I think that makes sense. I'm just concerned about that interim bureaucratic process of having to give notice for everything relating to a procurement, and I don't think that's what was
There's no doubt if this, but do all the cities have what you have where you actually do that? Because that's a fantastic way to do it.
The smaller cities that don't have the level of staffing, contract administration departments, legal staff on, it's a little more organic in the beginning. Mm-hmm. And even we do a lot of, when we buy things, we piggyback a lot. And I'm assuming that if we're piggybacking off a contract, there's no selection process involved in that. You're going to make the assumption that the contract we're piggybacking is valid.
Mm-hmm.
That assumes the piggyback prices are good. We found that necessarily is not the best deal.
But honestly, there's no physical way for me to go out and do a procurement process for all the things we buy. And that gets back into the definition of waste and mismanagement. Because we don't. I could be held liable for that, potentially.
As long as you're applying the law.
Well, and the law allows us to do the piggyback, so that's off the table. But for us, when we get to the selection process, it's pretty well, it's down to the point where we're making a choice at that point, and that's when we pull the committee together. And it's usually my department directors, they do everything. So that's when we would notify you, or most cities, I think, with the exception of maybe the larger ones that do it the other way. Is that okay? Is that we're on the same page here?
I mean, clearly, I like your idea because that's the easiest way to do this. If we know ahead of time, we can get in. But at the end of the day, as long as the solicitations are they public noticed, every one of yours?
Mm-hmm. Yeah.
Selection committees have to. If they're going to select, they have to. That's a 119 meeting.
And I think it's nice to have you there and your staff there to help hone those things. I just don't want to get in trouble with the fact we didn't follow this other process, and you're going to say, well, our recommendation is that you have a contract administrator and, all this staff. I just can't do it.
Yeah, no, and we're not asking for that. Yeah.
Okay,
So where do we leave this?
Well, if
I'm looking at Mr. Berger.
Yeah, my recommendation, because I thought the language was that the important piece was what Mr. Bornstein just talked about, where a selection is going to occur, where there's a duly public noticed meeting where the selection committee is going to choose a vendor. That's a bright line for every city to be able to follow. They know when somebody's going to pick a front-end loader or pick an architect or a design team, and that's very easily noticed. And that's the language that I actually drafted, which was when the selection is to occur.
Ms. Steckler wanted to have at it maybe earlier than that. in the event in terms of even getting into the specification process and to make sure that the specs are not proprietary, to make sure, so to get into, I don't know if you want to get into that level of detail, but that's a, I mean, if the process is tainted at the beginning, then it doesn't make any difference about the selection committee.
Mr. Chairman, I'd submit that if you have problems in the process where she enters and starts to look, if she sees something that, then you can back up into the project. There's just no way to see it all at once all the time.
Yeah, I think Lane, do you have language?
I think that what we've been doing is inviting the IG to all the publicly noticed selection meetings. So all we need to do, and it sounds like you're okay with that,
Yeah,
is just change the first line to say notified in writing prior to any, because we say duly noticed later on in the paragraph. So what we would be talking about are duly noticed public meetings of a county or county or municipal selection committee. And I think there's your bright line.
Okay.
Yeah, and then those cities and those that want us in ahead of time, which we have, invite us in because they'd rather have it preventative.
The only other addition, Mr. Chair, that we would request is the last sentence that I've drafted to just make sure that we're not giving any right to an unhappy vendor.
Agreed.
Okay. All right, I think we can, Mr. Berger will take that in, Mr. Berger will take that information, come up with the revisions to that section, and we can call that a victory.
Thank you very much.
Not a quick one, but a victory. I am up to Section 2-42310. This is, Mr. Berger had a complete rework of this section. If you look at his memorandum of February 9th, there is a complete redo of this.
Just a little one. You can see the, and actually, we met with the selection, now you've got me saying it. The funding committee, the funding subcommittee this morning.
Selection committee.
Yeah, and there's some slight changes, but basically what this does, this was in response to your request that we make clearer that the IG can contract with other entities to audit discrete parts of their operations and to even effectuate certain parts of the ordinance. So if you look at gee whiz, is it line 20 is where I think I tried to make sense of this. The prior amendments are in blue, and what I added now is the underlined language in black. Does everybody has black on their printers still, right? Okay. So what it does is it allows the Inspector General to provide independent oversight of any or all of the public entities' transactions. And the existing language also exercise any and all authority and functions in the ordinance. And that was something that I think you all had asked for earlier. So that's why it's in there.
I have a question.
Yes. Go ahead.
By taking out the word municipalities, is that somewhere else? Is that why you took it out?
No, the reason that this section only applies to governments that aren't subject to this by virtue of the
These are
charter.
the opt-ins.
So this would be the school district and and all of the other people that are clamoring to join.
Yeah, okay. See, everybody's saying the cities won't enjoy the benefits of this, but everyone else will. Okay.
They already enjoy it.
Okay, they're already enjoying it. They're enjoying it right now.
Mr. Chairman,
Yes, sir.
one question of Lenny, and I think it's really of the group. When I read this section, it says the fees shall be based on a rate established by the Inspector General to cover the cost of such benefit and shall include but not be limited to 1/4% the funding base of contracts subject to the Inspector General review under the agreement. That assumes that the engagement of the Inspector General is to look at contracts and not to do other things, like look at human resources functions, look at procurement processes and that sort of thing. So would you conclude, if you were asked to, that this would allow the Inspector General to come up with whatever fee they chose for looking over those kinds of services?
Actually, this says that the fees not the scope of the services, but the fees are based on a rate, including but not limited to this funding base, which is required language because of what the charter says.
Right.
So it can be based on that amount to look at anything, which is sort of what's suggested earlier in the paragraph. And because the Inspector General can request something lower than 0.25%, which is also in the charter, that can be established in the Memorandum of Understanding or interlocal agreement or what have you.
But I guess my only concern, Lenny, is I don't want the municipalities to feel that they're being taken advantage of by deals given to other people and not and I think that's part of what this is, and not fully funded so that they're paying, so that the 0.25% that they're paying is actually paying for services that other people are getting. I'm not sure that that's what this is about, but it occurred to me as I was reading that what we were looking for was equality, fairness in the billing process. And I think we'll have it under the Inspector General, but just don't want to fool ourselves in the language by saying we're going to collect something we're not, or telling the municipalities that something's going to be collected that isn't.
The only thing, Solid Waste Authority.
Mm-hmm.
Solid Waste Authority has this one-time procurement of $775 million. Obviously, we wouldn't take 0.25% of that because the budget would probably fill me for 5 years. So I think there was an attempt here to build in some flexibility for if a city or someone else has a very large project, which is not the norm, that it would be treated separately and we wouldn't automatically impose a 0.25% because we wouldn't need that much money.
Well,
whether that gets to any of this, I don't know, but I just want to.
We may be getting into Lager, which we can't get into today because we've let the folks who were interested in Lager go home. Well,
some of them are here.
Yeah.
Oh.
Mm-hmm. So, but I guess that's the question I'm going to have when we get to dealing with that Lager system is whether it truly is fair. I guess that's the issue.
That's probably the broader one.
Yeah.
This is still a vestige of the original ordinance,
Right.
which gave the IG as much leeway as possible to bargain with other entities looking for those services. So.
Okay. Recognizing that when we get back to the financing section, we might have an opportunity to look at this again. Are we, in concept, we're okay with this? Okay, great. I didn't want to wait too much longer for a no. I think we can get down to, according to this, my reading of the draft ordinance is we might be able to jump from subsection 10 all the way down to 14.
All right.
14.
And the subsection 14 is only to just add the language municipal and county funds. 2-423, 14.
What line number are you?
131 to 160.
Yes, okay.
That's acceptable?
So just adding municipal funds?
Right.
So moved.
All right, great. Well, we don't need a motion on that. I just want to make sure we've reached that demarcation point. Now, we are at a proposal for a new section, and that would be, this would be after the section 2-423-15. After that, there is a proposed new section titled Completion of Investigations. And that was in Ms. White's 217 draft.
Mr. Chair, I may save us a lot of time on this one.
Yes.
Actually, our standards require us to, obviously be timely. We actually have, and once, my office is actually established and up and running, administrative cases are attempted to be done in 60 days. So So we're actually lower than you even have. And the only exclusion, we have exceptions, and of course, a criminal case would take an exception where the criminal case would take the first, piece of that, and then we would come back later and finish for administrative controls. But typical administrative cases, we try to complete within 60 days, and the theory of that is the longer it takes us to do it, the worse it is for you, and you need to take action. Right. So we actually have an average of 60 days on our requirements, with exceptions documented. So we're actually much faster than 180 days.
No.
That's the goal. Now, granted, let me make a caveat. My office has to be set up and running, but that's the average.
Sure, and when you do, if you could just share those timelines with us, that would be much appreciated. Just again to give our cities notice of what's going on, what's expected, and so everybody knows.
And again, the standards. That's why these standards are so important. They require investigative plans to be done within 2 days. They require interviews to be written up within X amount of hours. So it's very strict. That's why the accreditation is such a valuable tool for no matter who's in this office for the future. It sets that standard. Timeliness is a very strong quality that's in those standards. So
okay, well then, since you have your own standards, that's probably not needed.
So we will not need to discuss the creation of this section then. That's great. All right. We are now up to section 2-420, I'm sorry, 2-424, subsection 2. I think we're okay under subsection 1 about the minimum qualifications, but there was some comments from Ms. White under subsection 2.
424.
It would be under the language that talks about selection.
7.
And I don't want to put words in the mouth, but it sounds as though what Trillo was saying is that there would not be municipal participation in the selection of the IG.
That is correct.
Okay.
And municipality.
So they.
This one. Yeah, they want to make sure that you haven't been part of a city.
Yeah, since my line numbering is messed up, I can only refer to the section numbers now.
If I may.
Sure.
And this will probably blend onto another section. This is the old unintended consequences. For me, it was easy. I wasn't from this county. This was a new startup, and it was important by the committee to get kind of an outsider in a way. But the future will hopefully present itself where a candidate could come from within my office, within a government entity. What I'm concerned about is for recruiting for the future, and not so much in this section as it is for, like, you cannot work in the government. I agreed to not work in the county government. It was easy for me because I know one day I'm going back to Tallahassee. But for future candidates, if a family moves here and makes residence here to work in the office, and they go ahead and they agree to be inspector general, and they have a 4-year contract, and they've come into a government retirement system, so to speak. If they wind up not wanting to pursue it after that 4 years for whatever reason, it was one thing when it was just county government that they couldn't go and be employed by. But when you add 38 municipalities, the unintended consequences for the future is that family would have to probably move, because there's very few government jobs that would, once the cities come on board, that person could actually go to. Perhaps maybe the state attorney or the public defender, but it limits the ability for future IGs that want to do this work, but knowing that you only have a 4-year contract may step away from that process. And I'm talking kind of generalistic terms with the whole removal, and because there's so many entities now under this jurisdiction, it makes it harder to recruit. And there may be some very, very good candidates in the county in the future that I'm not sure, and David, you were part of this committee, way before me. I don't know in 4 years from now if the will of the people would feel differently, that perhaps maybe there could be someone locally that could take over. Do we want to continue that? I don't know. I wasn't part of that process. My concern is that, like members of my staff, if they wanted to become the Inspector General, they're safer staying as a Director of Investigations and becoming IG, because they could be not only not renew, but they'd have to move to continue their time in government. So just food for thought as we go through these next few.
I guess I'm confused then. What does the word mean, shall participate in the selection of the Inspector General?
That issue's, I'm fine,
I'm
just talking general.
I think Ms. Steckler's talking about maybe sub 1 where it's talking about the Inspector General can't be employed by a county, any municipality, or any other governmental entity.
Yeah.
But she's saying that her staff, if she were to leave, her staff below her would not be able to move up to become an Inspector General because of the way this is worded.
Okay.
Well, I think, Mr. Chairman, I think it actually goes further than that, because now that the municipalities are there, you couldn't be in the internal auditor, for example, of the municipality and apply for the office of Inspector General. Right. And that's maybe a pool of highly qualified people. I think that's one. I mean, when this section was structured, it was structured very intentionally to keep anyone who was working here from becoming Inspector General, working for the county here from becoming Inspector General. I don't know that in the future that concern will be as keen as it was when this was done. I guess at this point, I don't think that's something we ought to try to address right now. Okay. I think that's for the future.
Is the consensus just leave it alone? Okay, thank you. The next is section 2-424, subsection 3, staffing of the selection committee. The addition here was suggesting a language that adding the word county human resources.
I'm sorry, did we all agree by consensus to strike out subparagraph 2, the first sentence?
They're not involved in that now. I mean,
right.
Yeah.
Okay, so
I'm not sure you.
Well, I think the only issue there, I don't think there's anyone. The issue would be is someone serving on the selection committee,
right,
as a designee of one of the groups. One of those is a designee of the League of Cities, but that's got to be someone who is not currently serving. The designee has to be someone who's not currently serving, so I don't think it really affects anyone.
Well, if I could just explain our reason.
Sure.
Sure, go ahead.
Crossing that out might make sense. We're saying that no official or employee of any governmental entity shall participate in the selection, but then later on in the same subsection, or I'm sorry, in subsection 3, we say that the county HR department is going to help. And then we also say that the county attorney's office is going to help. So if those two departments aren't allowed to help, according to sub 2, that's an inconsistency. So that's why we took that out.
I think, Mr. Chairman, if I might, I think that the purpose of that was just to make sure that no one on the selection committee was an official or employee of any governmental entity. I think kind of working back through that.
Well, so would you be okay with language saying maybe no official or employee of any governmental entity subject to the authority of the Office of Inspector General shall participate
on the selection
committee?
committee?
Committee for the Inspector General?
I think that's okay. Yeah, that's
okay.
That was the point, I believe.
All right, read it again. Just restate the sentence.
I'll try to remember what I said.
Okay, it was great.
No official or employee of any governmental entity subject to the authority of the Office of Inspector General shall participate on the selection committee of the Inspector General.
Yes.
Okay.
That's what I heard.
We have consensus on that. So, Mr. Berger, you can incorporate that language.
So can you say that?
Change in to on.
On the selection committee?
And
yes.
After selection, add the word committee.
Good job. Good. Okay. Are we up to 2-424, subparagraph 3, about adding the county human resources, and then to add and actually what Trio I had proposed, Ms. White had proposed, is to basically break this into two subsections. One would be to 3 would be, subsection A would be adding the word the county human resources department and just leave it as it is, and then add a second subsection that said B, the county's attorney's office shall provide legal services to the selection committee. So it's just an organization. But it does, in addition to the county human resources, it does add that the county's attorney's office is engaged to providing support and assistance to the selection committee. That's a recommendation from Ms. White.
I think perhaps, Lenny, would you like to speak to that?
Sure, that's okay.
Sure.
It's all the questions have to come through the chair. No.
Yeah, they should.
Go ahead.
A is fine. B puts our office in an awkward position. It's one thing in the ordinance to have us negotiate the contract because, on the one hand, you're a county employee. On the other hand, we want as much functional independence as possible for the office. And heck, we could, if we're providing legal services to the selection committee, we could be doing so in the context of her removal while she's investigating our office. So I don't think we want to go there.
Just for a clarification, the reason we had put that in there was more because we didn't understand what sub 2 meant, that first sentence we just talked about participation in the selection process. So
really, what we did is all we do is help negotiate the contract, then present it to the selection committee the way we negotiate a contract for the county administrator, the county auditor, county attorney.
I'm fine with withdrawing that
Okay.
recommendation.
Thank you.
Thank you.
But we will add county human resources. Okay. Okay, we are up to a proposed new subsection 6, 2-424, and let's see where are we at on that. The language has been proposed is except for the staff listed in paragraph 3 of this section, no official or employee of any governmental entity should be subject to the authority of the Office Inspector General shall participate in the selection. I think we've covered that.
Well, again, it was because we were reading
Okay.
sub
So we
2
get rid of that.
differently.
All right, so
we
we're
can
good.
eliminate that.
Okay?
Cool. All right.
We are starting to move. 10 minutes to 5.
So we're not adding that.
No, we're not. No. Okay. All right, section 2-427, and this is the procedure for finalization of reports, et cetera. Would by any chance the accreditation standards help us out on this?
Actually, it does, but it doesn't. The standards do actually talk about the current way that's being handled as far as sending the subject of response to the investigation and then the audit findings. But I will tell you, the delay of this hurts management. What happens typically is when we send the responses to the subjects and give them almost, if we have looking backwards, if you have 60 days that we complete an entire investigation and we give 20 working days, which is really a month for someone to respond, our cases literally sit for a month before we can get it to you as management. And so what we typically find is either A, they don't respond at all and we're waiting the 20 working days, or B, they wait to the 11th hour on the 20th day to respond. And so what this process does, as important as it is to have people respond to the findings against them, it delays the process for me to get it to management timely and for you all to do what you need to do. So this delay of the time for actually, the cases just sit for a month on the desk and we can't release them. Flip side, the traditional audit standard is 20 days response. That's typical. Now, on either case, we can give exceptions. Someone can call us and say, I've been on vacation. We absolutely give them another week or 2 weeks, whatever they need. So we've always extended if they need it. But most of my practice in my years at Department of Children and Family, the majority never even respond, and we're sitting here holding a report for a month before we can get it to you all.
I think Ms. McKenna, I can't remember, but I think in her comments she had requested that maybe we put something in the ordinance saying that within the Inspector General's discretion, these times can be extended. Because my concern is you might have had 60 days to do an audit, and you've only given the person 20 days. They might need to hire their own auditor. It's difficult. And with respect to just responding to allegations, they might want to get an attorney, take a look at stuff. So I would feel better about those proposed timeframes if there was something in there saying that you could extend it.
I don't have a problem with
Right.
extending it if requested. That's fine. It's just, most of them sit, again, most of them just sit, and I.
Okay, Ms. McKenna?
Yes, thank you, Mr. Chair. I had two comments, actually. If we could insert the words after 10 days and 20 days from the date of receipt, so that the party has the full 10 days or the full 20 days to respond. And then the second comment was to give the Inspector General the discretion, based on a finding or an audit, to expand the time. If, for example, it was an audit of some really complicated or complex process where clearly, if there were 150 findings, you would need more time. And so I would just want her to have, or the office to have the discretion to expand whatever deadlines are in there. And by expressly giving her that discretion, then nobody can challenge the procedure. And I'm trying to look for everywhere that we can eliminate somebody making a claim that because it said 10 days, you're going to,
I have no problem if we put some kind of language like upon request for an extension. I have no, and we have that in audit world where management, I'm dealing with one right now where it's pretty extensive, and we obviously want to make sure that there's enough time. So I have no issue with upon request and extension. It's just the shorter we can keep the time frame, the faster I can get it to you
All right,
all.
well, that
There's
takes
no
care of the
request.
first part, but I think the second part of Ms. McKenna's comment was.
Date of receipt.
Right.
We build in a mail date of a day, or we actually build in an extra day of mail date. Some we do by email. It just depends on the person. The hard part will be is, technically the law says if you send it, it's out. It's, you don't prove receipt. We don't send these by certified mail because it can get very expensive. So that's the only, how do you?
And it's a challenge. I think you want to try and identify, and it may not be date of receipt, but I think you have to identify the way that you're going to ensure that a respondent has 10 days, a full 10 days, so that you don't have a gotcha situation where they get it on the 8th day of the 10 days, and it happens from time to time. So I think we as the regulators have to be careful that, we give the 2 periods.
I think Ms. Rainey may have an answer.
Well, no, actually, I just wanted a clarification. I understood you to say that you did not have any issue with automatically extending that time.
Mm-hmm.
So perhaps that's a way, upon receipt of a request, the number of days may be extended an additional 10 or whatever number you all think is appropriate. An additional shall be automatically granted. Or however you want to say it.
Just giving her the discretion to extend so that if, for example, on this past Friday, City Hall was closed, if it had been delivered to City Hall, it would not have been seen until Tuesday.
We actually add in the holidays and all that.
Yeah,
But clearly,
yeah.
I have no issue with extending. We want the responses to come in.
And I think
Yeah.
we do it as automatic. So it's not discretionary, it's just automatic. And that gives a comfort level to people that I'm going to have sufficient time.
For Mr. Berger's benefit, is there going to be any language changes that are coming as a result of these comments?
I think you should add a sentence that says the Inspector General has the discretion to expand the time periods for response.
I agree.
Yeah. I don't have a problem.
Okay, good.
Happy with that.
All right. I think we're to a point of,
There were, sorry.
No return.
There were some comments towards the front of that section.
okay. All right, let's go back into then 427 for the procedure finalization of the reports. Go ahead.
And again, Ms. Steckler, you might have internal procedures to address this stuff. I just don't know what they are, so that's what we were trying to get at.
For release or where are we?
For the procedure for finalization of reports?
Yeah, we have a complete procedure on that and where it goes. And actually, once we get the subject response, if there's no additional work needing to be done, we immediately, once we update the report, it gets released that day or within 24 hours. If, in fact, the subject responds to us and there's actually issues, we may go and reopen the case and go back out. So those are the 2 elements that can happen. But once we're done, it's out.
Okay.
Okay, I think we're going to stop. We are stopped at section 2-428, which is reporting. And for the next meeting, which is March 23rd, it would be beneficial for us to have the redrafts of all the sections that we've worked on so far. The league, if you're going to prepare some language on some definitions, that would be helpful to have that. For purposes of the agenda, I would like to have, if we're meeting on the 23rd, you don't have to open it on March 17th, but to have it available and out to the committee by no later than March 17th, which would mean that back your work up to plan for that so that we've got, yes, it is. That's why I said you don't have to open it on the 17th, but it ought to be received on the 17th by the committee members. So, I mean, that would just help Tammy out in terms of working out the logistics. So mainly the onus is going to be on Mr. Berger and Trila and Jennifer for most of the work here. So speak now or forever. That doable?
Yeah, the 17th is fine for us.
Okay. Yep. Yes.
Mr. Chairman, I will be in Tallahassee. Will be unable to attend the next meeting on March 23rd. So I'd like to request an excused absence or maybe a replacement for that meeting. I was thinking of maybe Alex Larson or something. I can ask. She's actually a friend. I can say that.
Yeah. What's the how we want to handle that? You got to go. You got to go. That's good. But you have obligations there. I understand. So, yes, Mr. Baker.
I'm pondering that.
Well,
which
part? Well, actually, you're not going to be here between.
Yeah, it's not. It's,
He's choosing his words very.
What is your schedule? Without getting too personal, Dave, what's your schedule? Are you out of?
I'll be gone for most of March and April for the legislative session.
Okay.
I'll be working out of Tallahassee.
All right. Is it possible for you to participate by phone?
Sure.
Is it possible for them to participate by phone?
I believe it is. You have it around there, we just put on speaker.
Sure. I can phone it in. No, that would be fine.
That would be a good workaround, I think. That would be helpful. We really do need your participation.
We do.
Okay.
Involvement.
Okay.
Okay, so the next meeting then is March 23rd at 1 p.m., and look for your agenda packets on or about, well, certainly no later than March 17th. Thank you.
Move to adjourn?
Yes.
I'd just like to take a point of, and I want to thank the county staff for the difficulty in this and keeping track of everything. Y'all done a great job getting us the information. Thank you. To my fellow committee members, good meeting.
Thank you.
You guys are professionals. Yeah.